If somebody else can go ahead and get that started, that'd be great.
Okay, yeah. You want me to do roll call?
Yeah.
Okay, I'll do it.
Good afternoon. Welcome to this regular meeting of the Rehoboth Beach Planning Commission. We moved the time earlier today to create enough space to make sure we could get through all of our work.
I'll go ahead and call the roll since Sean just got here. Commissioner Davis? Here. Commissioner Ellison?
Here.
Commissioner Dewey?
Here.
Commissioner Stockdale?
Here.
Commissioner Strange is not here yet, but I understand he's on the way. Commissioner Hunter is absent. Commissioner Stewart is absent. I, Commissioner Gay, am here. Commissioner Bryan?
Here.
We have a quorum.
Have a quorum. I declare this a meeting in order, please. Ms. Womack, would you please tell us about the publication of notice for this meeting?
The agenda for the planning commission regular meeting was posted in City Hall and on the city portal on May 1st and was sent out the same day. The agenda was amended and reposted in City Hall and on the city portal on May 7th and May 9th. Public notice for public hearing of partitioning application number 0224-01 of property located at 10 Columbia Avenue was posted in City Hall and on the city portal on April 18th, 2024. The public notice was published in the Cape Gazette on April 23rd and April 26th, and in Delaware State News on April 24th and April 26th. Public notices for public hearing of site plan review application number 0323-01 for the property located at 413 Rehoboth Avenue, application number 0323-02 for the property located at 415 Rehoboth Avenue, and application number 0323-03 for the property located at 417 Rehoboth Avenue, were posted in City Hall and on the city portal on April 18th. The three notices were published in the Cape Gazette on April 23rd and April 26th, and in Delaware State News on April 24th and April 26th. Notifications specific to each of these three projects were mailed out to property owners within 200 feet, and signage was posted on each of the properties.
All right, Ms. Womack, as a formality, since we're conducting a public hearing today, do you swear and affirm that the information you provided here today and will subsequently provide is true and correct to the best of your knowledge and belief?
Absolutely.
Okay. All right. In terms of agenda items, the first matter that we'll hear today is a continuation of a public hearing of a petitioning application for 54 Kent. Oh, 10, okay. Sorry,
We're changing the order?
we're changing the order.
Oh, okay.
Keeping us on our toes.
Didn't mean to get everybody excited. Settle down, Mr. Robertson. 10 Columbia Avenue. Who's the president? Mr. Townsend?
Yes, sir.
Now, for just the history of this application, we've already had proceedings about this application, and then there was basically a continuation in between, and during that postponement, the Board of Commissioners changed or adopted additional code provisions that had previously been deleted, and so you waited until that had taken place, and then here we are today. Is that correct?
That is correct.
Okay.
That is correct. We had a preliminary hearing in March, and by the way, I am, for the record, Fred Townsend of Hudson Jones, J. Work and Fisher. I'm here with my client, Michelle Reckert. She is the co-trustee of the Yates Family Trust. Could you raise your hand for us, please? And her husband, Peter, is with us also. We did have a preliminary hearing that resulted in I believe, a unanimous vote to move this to a public hearing, which was anticipated to be held in April. And then given the intervening efforts on the part of actually the Planning Commission, quite frankly, and thank you very much for that, the landscape changed somewhat with the adoption of an amendment to the zoning code, which eliminates the need for us and renders moot a tedious legal argument that we might have had to enter into. So again, I thank you for your efforts to make this a more streamlined process.
Yes, sir. Please proceed.
Thank you. Let's see, so this is an application for a lot separation of lots 10 and 12. I've discussed how we got here today, and I want to call attention to the fact that that ordinance change that was just referenced, I'm going to refer to it as a safe harbor statute or a safe harbor provision, which authorizes this body to grant the approval of lot separations in instances where the lots don't necessarily meet the standards for a new lot, which are 50 feet by 100 feet of depth, 50 feet of road frontage and 100 feet of depth. That's what's required to create a new lot. Given the adoption of the zoning change, what we have instead now is that this Planning Commission is authorized to approve a lot separation where it meets the criteria of subsection C of the applicable ordinance, which allows for a subdivision of lots where the resulting lots would have a minimum of 48 feet of road, or 48 feet on the shortest side, and a rectangle of 4,000 feet. So these lots easily meet that standard. So at this point, I do have some slides. Their primary benefit might be just to enable you to follow along with your with the record that has been submitted to date. I do have a couple of additional items which I'll touch on here shortly. That you cannot, I'm sure you cannot read this. This has not been submitted before, but this is a chain of title which shows that the Yates family took title to this parcel in 1945. The history that I'd like to call your attention to in this instance is that this property was offered for sale, originally listed in, I believe, July of 2021. So it was originally listed for sale by Marvin and Gail Yates, who have, as you can see from this, have subsequently passed away. On July the 5th, 2022, Marvin and Gail obtained a lot separation approval issued by the city that was conditioned upon demolition of the property, and that approval had a lifespan of 6 months. So it expired on January the 5th, 2023. Why did it expire? Well, in December of 2022, Mr. Yates succumbed to his last illness, and subsequent to that, on August the 5th, Mrs. Yates passed away. So that's why the conditions of approval were not met during the 6-month time frame. This may be of some significance to the group, but the property was for sale at that time. It had been for sale for virtually a year prior to that. And then I'd had communications with the city solicitor about the filing of a new application or an extension of the old application. And remember, at this point in time, the Planning Commission was not involved in matters of separating lots to their prior configuration. That was an over-the-counter, purely administrative function. There really wasn't an application, a prescribed application for doing it. There wasn't a very formalized process. You just simply wrote a letter, sent in the materials that your building inspector would require to come to the conclusion that you were returning the lots to their prior configuration. And then a resolution would be signed by the city manager. I have that one in your packet to review. So it wasn't, so what happened next for us was that the commissioners entertained a resolution to repeal the administrative lot separation process in August of 2023. Several days earlier, following a lengthy delay between my initial communications with your prior city solicitor, it was the application that was ultimately not acted on to extend the separation or get another approval to separate these lots was submitted on August the 16th. So our application was in August, and it was declared on September the 15th to be pending as the commissioners approved the ordinance change which empowered this body to approve lot separations. So many conversations took place, and I don't need to bore you with those details. They didn't involve the Planning Commission, of course, and but the final upshot of all of that was that the city was not going to exercise its authority to treat that application under the then current law when it was submitted in August, and we got that final determination on December the 5th, which then caused us to file an application with the Planning Commission. I would characterize that as not so much as a denial, just simply that the city wanted the Planning Commission to play this role in the process. We never got anything that I could characterize as a denial or anything in writing. So just some of the, I'd like to check a couple of boxes here. The first thing, or what I have on the screen now, is the deed by which Gail Yates transferred this property into the Yates Family Trust in 2011. And that is a 3-page document. And then I also have included in your package a certificate of trust whereby the successor trustees are identified as Michelle Record and her sister, Beverly Walter.
Mr. Towns, just for the sake of the record, when you're referring to documents that have been submitted as part of the package, have these been already submitted as part of the record for prior hearings? And if so, do you want to make it clear that you're incorporating those documents into the record for today's purposes?
I do. Thank you very much. The only document that you've seen that I've shown that's not already been submitted, and of course I wish these documents to be made part of the record, was that chain of title and that little timeline that I put together. I've got, of course, a copy of this presentation, which I'll submit. So the certificate of trust is the appropriate instrument I would submit for identifying who's authorized to act on behalf of the trust. The next document I'd like to call your attention to is the prior separation that was granted in July and expired in January of 2023. So this was an approval that was contingent upon removal of any offending structures. Those structures were the primary dwelling or the residence on the property, as well as an outbuilding. And then I think a catch-all provision is that to the extent that there are any other improvements on the property that potentially violate zoning as a result of the subdivision, they'd have to be removed. Just to orient you a little bit, this is the tax map showing the location of the property. It's highlighted there. You can see the reference to lots 10 and 12. It's shown as one parcel on the county map. And then from the comp plan, I believe this is an image that shows lots 10 and 12 with the boundary line between the two still shown. That is not a document that was previously submitted. To further orient yourself, I've got some pictures here that are moot for the reasons I'll explain. We have a photo of the front elevation from across Columbia Avenue. This is, of course, the residence at 10 Columbia Avenue. There are two images there that had been previously submitted. And then, and then we've got pictures which incorporate something of the neighboring properties on either side. Those have been made part of the record, and these are showing properties lines adjoining in the rear to the extent that that's visible from the fences. The next item is a survey of the existing conditions, the then existing conditions at the time that the application was submitted. It's showing a two-story frame dwelling. Not going to spend a lot of time with that because I've got a more updated survey to show you. This is a proposed re-subdivision of the land showing the boundary line between lots 10 and 12 and where it lies in relation to the two-story dwelling. This was submitted in support of the application that was previously approved, and it is marked that any of the structures on the property were to be removed. The next item is a fresh survey from yesterday, because earlier this month, this is not in the record, but as of yesterday, a new survey has been performed, and I'd like to hand out copies of that, if I may. Please.
And this is to be made part of the record as well, correct?
Yes.
Okay.
And also, Mr. Townsend, if you would just, again, make it clear for the record, to the extent that you are proffering evidence as an attorney, just make that clear as opposed to having a witness provide that testimony, please.
Thank you, Mr. Mehta. I'd like to call your attention to the fact that what you have before you is a signed and sealed survey from a licensed Delaware surveyor who actually had performed the prior surveys as well as this one. This one is dated May the 9th, which was yesterday, and the need for this survey is to give you the current configuration of the lots, absent the dwelling. The dwelling was demolished on the 2nd. I think it might have been a 2-day process, but earlier this month the dwelling was demolished. So that the condition of approval that we previously received is now no longer needed because the dwelling has been removed, and the any other offending structures have been removed as well. So there was a dwelling, an accessory dwelling in the back right corner. I'll say that it was on lot 12 in the back right. That no longer exists, nor does the main dwelling, of course.
What about the shed on lot 10?
I don't believe there are any structures on the property.
Period.
Period.
Okay.
And have all impervious surfaces been removed too?
So it's my understanding that there has been a inspection performed on this. It's not my understanding that there are any conditions on the property that require remediation in order to allow this approval to take place. I see our building
Has it been
inspector may have
inspected,
played a
Matt?
role in
I'm just confirming that the inspection has been entered. Give me a second, please.
It's a good thing, I remember we talked about the timing when you were here last time. It's a good thing the demolition's already been done, because otherwise you'd be in that period of the year where you can't. So I think that's good.
Ms. Gay, I appreciate the question or concern that you voiced at the last
Yes.
meeting over how feasible it was that we could avoid having to come back another time and ask for this board's attention on this. So this is the best image probably for me to make the assertion that given the application or given the amendment to the ordinance that permits this body to authorize the separation of lots that offer less than 50 feet of road frontage. This image is showing that the road frontage along Columbia Avenue for these two lots is 49.917. It's, as I understand it, it's about an inch short on each lot. It might be even less than that because there's some rounding that goes on, but there's an expression about being so close and so far, and we were both very close and very far from where we would hope to be. So with the adoption of that ordinance, we can clearly meet the standard that we've got a rectangle of 4,000 square feet present on each of these two lots, and that none of the lot lines is shorter than 48 feet.
Hey, pardon the interruption, Fred. A final inspection was completed on 5/8/2024.
And it is clear, completely clear.
Yes, ma'am.
Thank you.
Mr. Janus, since it's a public hearing, do you swear and affirm that all information you give here today is true to the best of your knowledge and belief?
I do, Chair. Thank you.
Thank you.
Okay, so at this point, I think those are the merits of the question as to whether or not these lots can be lawfully created or whether this larger parcel can be lawfully subdivided to its original configuration. I've been made aware that although this application did go through the preliminary hearing process and was sent to a public hearing, I may want to discuss the irregularity of the existence of the contract with you. You have a long day. If I don't need to do that, I won't, but if I do, I'm happy to
I think
lunch
it may
and-
be helpful.
Okay, thank you. All right. So again, what I can tell you is that this property was listed for sale in July of 2021 by Marvin and Gail Yates. It's been an ongoing effort to sell the property since the summer of 2021. In July of 2022, the lot separation approval was issued, as I stated earlier, and that due to the condition, the declining health of the then co-trustees of the Yates Family Trust, Marvin and Gail Yates, that demolition and those conditions were not met, allowing for the lot separation to take place. That's why it did not happen. So subsequent to that, and quite frankly, without any knowledge of any pending change in the ordinance, the applicants, namely me, submitted a lot separation application on August the 16th of 2023, which, as I said earlier, was recognized on the record during the commissioner's hearing in which they enacted on September the 15th the ordinance change. So the ordinance change, which moved this from an over-the-counter administrative process to a quasi-legislative process involving the Planning Commission, I would argue shouldn't have affected our application. But regardless, the application that we submitted was entered, or the contract that was entered into in advance, well in advance of any knowledge that we could possibly be before the Planning Commission. Now, the Planning Commission statute, or the provision of 236-5, which we're addressing here, prohibits any involvement or prohibits an application from proceeding through the Planning Commission in the event, well, let me restate that. It subjects the applicant to a penalty if they fail to disclose, or if they enter into a contract on any matter that's pending before the Planning Commission. But that contract that we've disclosed at every step of the way, including when we filed this application and during the course of every meeting that took place in anticipation of filing those applications, that agreement was always made known to the city and made known to this body when the application was filed. So there's been certainly no effort to hide the existence of the contract. I would say,
Mr. Townsend, just for the record, because I'm not sure it's clear, what's the date of the agreement of sale?
the effective date of the agreement of sale was September the 8th of 2023, September the 8th. And that was in advance of the adoption of the ordinance. And it was, but also importantly, it was following, it was several weeks after the application to separate these lots had been submitted. So we'd already submitted an application, which was acknowledged to be pending, and in my view, there was no reason to think that the provisions of 236.5 would have applied, because we weren't envisioning any kind of a hearing before the Planning Commission. And remember, before that change to the code, there was no applicable prohibition against entering into a contract. That provision only applies when the Planning Commission is involved. And it doesn't arguably apply to anyone who is pursuing an administrative approval through the city, which is what we were doing. So I think that's very clear from the statute. But what is the ordinance designed to prohibit, or what is the behavior that this ordinance is trying to further or to restrict? And that is that this process of creating new lots that the Planning Commission has always been charged with involves a public hearing. And it would not be appropriate for people to testify before this body in favor of one option versus another for subdividing a larger tract of land if they had contracts to purchase areas of land that had not yet been separated. So if you could have people saying that lot number 24 needs to have a 75-foot road frontage and not a 60-foot road frontage because that's the agreement I made with the developer. And that would have an effect of damaging the integrity of the process if people were testifying and trying to influence the outcome of a major subdivision approval because they had personal interests in how that approval was granted. And that's evident from the subsections in that ordinance in a couple of places I'd like to call your attention to. Subsection B of 236-5 refers to whether or not streets in the subdivision have been created yet. So imagine, this is really envisioning a scenario where subdivision is, where the roads aren't even laid out yet, and we don't want people selling lots in an area where a road has not yet been created because it may never get created or may never get approved. So that gives you some context for what it is, for what the public policy might be for having this prohibition, and it really doesn't apply in our case. I think our case is also different in that under subsection C, the relief that a would-be purchaser of a lot that had not yet been approved is to have a lien on lands that remain in the possession of the subdivider. So this is information which I think sheds a great deal of light as to what it is that the city, in approving this ordinance, is trying to accomplish. But in our case, the entire parcel or parcels are being conveyed to an individual buyer. There are no contingencies related to the approval. There's no discretion as to where this lot line's going to go. You're not being asked to do anything other than recognize the originally approved plotted lot line between lot 10 and 12. I think that makes a huge difference. I would also say that the authority to impose the penalty respectfully lies, I think, with the city and not the Planning Commission. So it's obviously not the Planning Commission's responsibility to prosecute people for violations of any number of ordinances. This is one of those instances where where the city, if they had chosen to enforce this strictly against us, I think would have stopped this application from proceeding altogether. So if we were of the impression that this prohibition was going to apply to us, we would have disputed that, of course, because our contract was entered into before the law was changed. But notwithstanding that, I wouldn't think our application would have been accepted. I don't think the preliminary hearing would have proceeded in the way it did if only at the 12th hour we were to find that the Planning Commission were to conclude that it could not proceed given the existence of the contract. That is a matter that could have been raised or enforced much earlier in the process. I believe that's all I have to say on that point. I'm more than happy, of course, to answer questions related to that issue.
Before that, Mr. Janis, you've had an inspection a couple of days ago. Are there any deficiencies, any issues?
Not that were noted during the site inspection, no.
So this application's ready to go?
To the best of my knowledge, absolutely, sir.
Yes, sir. Any members of the commission? Ms. Davis.
Mr. Townsend, I want to, as a preliminary, oh, I'm sorry. Excuse me. I'm not contagious. I just have allergies to pollen. I want to be clear that I have every sympathy for your clients. We've all had elderly parents who've had health issues and ultimately deaths. And things tend to fall through the cracks, and I can well understand how the original approval might have expired without a timely request for an extension being filed.
Thank you.
But that was then and now is now. Subsequent to that, it's my understanding that the city started discussing the fact that the legislation that had been approved previously, or that was on the agenda, that there was legislation that was going to be at least proposed, entertained, to restore the authority of the Planning Commission to hear subdivision partitioning cases. And those discussions commenced in March of 2023. Subsequent to that, on August 7th, 2023, the Board of Commissioners at a workshop, duly noticed and recorded, adopted a draft resolution and related ordinance amending 2270-46.1, which is the ordinance you're discussing, that they finally adopted after public hearing on September 15th, 2023, which was 2 days after your client's contract was signed. And then subsequent to that, I gather, I'm not sure I've got all the dates right, but your clients had requested the city to extend the original approval for petitioning, which was turned down in December of 2023, last December. And then your clients filed a new application in February of this year, which is the application that's now before us. Is that roughly the history?
I think that the dates are roughly correct. I wouldn't characterize what we filed in late December as a new application.
No, I'm sorry, the application that you had filed earlier, you had requested an extension of the original partitioning approval, the 2022, July 2022 administrative approval. You had requested an extension of time for that, which, as I understood what you said, and I don't think it makes any difference, by the way,
Right.
to this discussion, but that was denied, as I understand it, in December,
I don't,
past December.
so I would characterize it a little differently. I would say that I resubmitted by letter the application that was approved previously.
Right.
I've resubmitted that actually in July in draft form, July the 10th, and then subsequently on August the 16th, I submitted it in final form. I didn't characterize that as a request for an extension of an expired application.
Well, we don't have to debate that.
Right.
If I mischaracterized it, I apologize, because I don't think it's all that relevant to what I think is the real issue here, which is 230, the statute, 236-5, that says, if before final approval has been obtained, any person transfers, sells, or agrees to sell as owner or agent any land which forms a part of a subdivision on which by ordinance the Planning Commission is required to act, such person shall be subject to a fine. Now, I gather it's your position that at the time that contract of sale was entered into, authority for partitioning had not yet been transferred back to the Planning Commission.
That's correct.
However, I'm sure you are familiar, well, with two things. First of all, the application instructions for a partitioning application, Planning Commission instructions for partitionings in minor subdivision states in paragraph 9, warning regarding agreements to sell or transfer property. Applicants should be aware that section 236-5.A of the code states that it's a violation of law if any person prior to approval of a subdivision, quote, transfers or sells or agrees to sell as owner or agent land which is part of a subdivision on which the Planning Commission must act. And then it talks about contingencies. It further states it is illegal to enter into any agreement, written or oral, that would transfer to any party either of the smaller lots proposed to be created with a partition, even if that agreement is contingent on favorable action by the Planning Commission. No agreement for sale, contingent or otherwise, is permitted until after the Planning Commission grants an approval. Now, as I understand it, leaving aside what happened last fall with your request that the city consider the original partitioning application still in force, your clients filed, you and your clients filed this new application during the pendency of a contract to sell the property. And I'm sure you are familiar because the case involved the Board of Adjustments, the pending ordinance doctrine. And Mr. Mehta raised that with you at our March meeting, as in addition to these issues with 236-5, the pending ordinance doctrine, which judicially creates a principle that allows a municipality to deny an application for property use, which even though it's made in accordance with existing law, violates the law that is pending when the application is made. When the pending ordinance doctrine applies, the applicant may be required to conform to the proposed zoning or other regulations that have not yet been formally adopted. In Delaware, as I'm sure you know, this doctrine was upheld in 2017 by the Delaware Supreme Court in the Covington versus City of Rehoboth Beach Board of Adjustment case. Now, given the fact that in August 7th of 2023, which was prior to August 14th or 16th, when you asked the city to reconsider or to consider the original application still in force, and was before the contract of sale was entered into. which was September 13th, as I understand it. But as of August 7th, 2023, there was a pending ordinance. A draft resolution and related ordinance had been approved together with a public hearing set for September 15th. Why wouldn't the pending ordinance doctrine apply in this case?
So that's a long question. I'll do my best
No,
to
no,
address it. But I would say, first of all, that as far as the pending ordinance doctrine is concerned, I think the city had the opportunity to declare that the ordinance was effective going back as far as its initial public hearing on this. So when this ordinance that we're speaking of in September the 15th was adopted, it declares that its effective date is September the 15th. So it's not purporting to say that this is effective as of an earlier date, which it could have in accordance with the pending ordinance rule. But it's by its own terms, it's effective on September the 15th. And it was September the 8th that the contract was entered into by the seller.
Well, that was its effective date. It was entered into, signed, as I understand it, on the 13th.
The contract?
Yes, that's what you testified to previously, and I think you provided a copy of the contract.
Well, there are some dates on the contract that were prepared because they were typed. They were prepared anticipating that the contract would be signed on the 12th, I think. But I think the dot loop signatures on the agreement of sale were the 8th. I mean, I don't think it matters a great deal, but the seller, as I understand it, entered into the agreement, which made the agreement effective on the 8th of September. It's just a few days earlier than that.
Well, I understand that the city could have, or the Board of Commissioners could have included in the ordinance that it was retrospective back to when these matters first occurred. And I understand it didn't. But I'm not aware, and I've read most of the cases, that there's anything in the pending ordinance doctrine itself. They could have done it, but they didn't. That there's nothing that is not legally significant. The pending ordinance document is the pending ordinance document.
So
Doctrine, I'm sorry.
With that, I would say that the city has not, during a very lengthy period of time, evidenced any desire to enforce that prohibition against this applicant. And I think it's the city that's authorized to assess a penalty in this case, not the Planning Commission per se.
I don't dispute that it's the city that could enforce a fine for the violation. My issue is that the ordinance has been violated, whether the city, in its discretion, has chosen to fine your clients or not.
Could I comment on, I mean, I hope that the majority of you don't feel that way about this application, but I respect your comments. Ms. Davis, I would say that when you called attention to the application itself that contains this prohibition, I need to say in response that when, following December 5th, again, I wasn't told that our application was denied. I never got anything in writing. I was just told that your application needs to go to the Planning Commission. So what does it take to get an application to the Planning Commission? Well, I was then told by a city staff person who's in the room that there's no application that exists for this type of application. There is none. It was being developed, and that I could proceed using your existing application, but I could ignore huge swaths of that application, including pages. I mean, it says ignore pages 1 through 7, fill out page 8. These were my instructions. Ignore sections B through K, fill out L and M. But the prohibition that you read to me was not a section that was meant to apply to me by the instructions that I received by email from the city staffer. So I did not view that as applicable, again, because we while the city manager's authority to grant this approval had been divested, and the Planning Commission's authority to grant this approval was vested by that change in the ordinance, in my view, it's still an administrative process, because there was nothing in the code at the time that granted the Planning Commission any authority for evaluating these applications, other than, as was pointed out in the report that the building inspector prepared, that the lot line that's being proposed is already plotted. So there really wasn't any discretionary process involved, and in the absence of any discretion, given the context of the instructions I was giving for filing the application, that the prohibition that you're speaking of did not really, that doesn't apply well, if at all, to us. Because again, we weren't denied, we were just told we were going to have to prosecute our application through the Planning Commission rather than through the city. And
Yes, I have no independent evidence or material to indicate or just substantiate what your communications were with various city officials, or, you know, whether you could or should have relied on them. But my only point is that I think under the plain language of the city code and the Planning Commission instructions, that for better or worse, it was a violation of law for the application to be filed on February 4th, which could lead this commission to deny the application outright. I'm simply saying that for my purposes, I would condition the approval on becoming effective when, at such point in time, when there is no pending contract of sale on the property. That's all we're talking about. The application and your proposal clearly meets the new and the old legislation, and, you know, the safe harbor provisions and so forth. And as I say, I'm very sympathetic to your client's position. They've demolished the house. Everything's in order. And if and when that contract of sale expires, either by its terms or by mutual agreement, at that time, it would be ripe for this commission to approve the application. Now, as I say, I don't have to go so far as to say we should deny it today. I would table it until such time as the contract of sale has terminated, either by its terms or by agreement of the parties.
I don't think it probably matters, but I can certainly proffer to provide a copy of the instructions that I was given by staff for filing this application.
I could give you a copy right off the website
Well,
of the instructions.
but the instructions were for an application that didn't exist at the time. There was no administrative lot line restoration application applicable. I was told to use an application which didn't apply, and I was told that I could disregard significant portions of it, and I could document that if it matters to the board. Or, excuse me, matters to this body.
Yep, Mike? Mike?
Anyone else? Now, Mr. Strange, you may want to recuse on this one since,
I wasn't here for the first part of it.
right, right. So, I'm sorry, sir.
That's okay.
Anyone else?
Oh, is it, I'm sorry, is it the case that you weren't present for the preliminary
Oh,
hearing?
he was late today.
I was
Oh,
late
late today, okay.
Due to health issues, sorry.
Anyone else? Anything on the factual, I want to make sure we have
Let's just
a
make sure we have a
factual
clear factual record here. Okay, so I'm just, on behalf of the, unless,
I'm a relative newcomer to this commission, so I hope I am not doing anything that's out of bounds here, but I do understand the discussion that just unfolded. And I'm curious about two things. The pending ordinance document or doctrine, does it have to apply, or is the rule of law it may apply? And then the second question would be, just to clarify, whether it applies or not would really be a distinction of someone other than this group. Is that correct or not? A responsibility to enforce.
Well, but
Someone
both,
other than our
both
group.
with regard to any retroactive application of an ordinance up to the Board of Commissioners, not this body. And I think it's already been made clear that this body doesn't impose fines, it's the Board of Commissioners.
Right.
So that maybe just one question, if for Matt or Mary Ellen or anybody else, is anybody aware of any intent by the city to impose a fine on this applicant under 236.5?
There's no action currently.
Does that answer your question?
It does.
Anyone else?
So maybe just, again, to make sure we have a clear record, we have a very full agenda here today. And Matt, can you just go through the basis for the application, including your reporting, your recommendations in your report on this application?
Certainly, you'd like to meet.
Just very quickly, you just summarize your
Absolutely.
February 15 memorandum, just to create a factual record, please.
Yeah, we are well aware of the lot that we are speaking of, and right now it's lots 10 and 12 with the tax map number 334, 14.09, 161.00. In this, obviously, the applicant desires to partition the existing one parcel into two parcels, creating one parcel of 4,997 square feet and another parcel of 4,993 square feet. One caveat that I put into my report is the following. Should the Planning Commission grant approval, a condition should be set that the entire parcel be brought into zoning compliance, which would be relative to the demolition, to include the removal of all main and accessory structures and lot coverages that cannot be identified as grass plants or natural mulch. Once the removal of all items has occurred, the Planning Commission may then require an inspection and further documentation to show that the conditions have been met and that the parcels may be created. I believe the document that Mr. Townsend has submitted showing the parcels as with structure-free, if you will, satisfies the additional documentation. And now I guess it would be up to the Planning Commission should you choose to set any conditions.
So again, just to be clear, is it based on your knowledge of the site now, what was introduced by the applicant, are you withdrawing your proposed conditions of approval?
Yes.
Including with regard to any,
Yes,
beyond the structure, you mentioned some impervious
Right.
covers. Are you still
The lots are
recommending
free-
that or not?
Yes, the lots are free and clear of structures. I believe it can go forward.
And this is in what zoning district?
This is the R1 residential.
In your view, again, I'm just trying to create a record. It's not a leading question, I'm just trying to create a record. In your view, does the proposed partitioning meet the definition of a partitioning as defined in 236.3, specifically, any subdivision not containing more than two lots fronting on an existing state, county, or municipal street, not involving any new street or road, or the extension of city facilities, and not adversely affecting the development of the remainder of the parcel or adjoining parcel? Does it meet the definition of a partition?
I believe it does.
Have the fees for the application been paid? The applicable fees?
I believe the fees have been paid. I'm just looking for my receipt. Yes, the fees have been paid.
Is it your view that but for the requirements of Section 270-22A of the code, it is not necessary to consolidate the partition lots to comply with Chapter 270?
Yes.
And is it further your view that each of the partition lots as originally plotted conforms to the requirements of 270-22A3, that is, each partition lot can fully contain within it a rectangle of at least 4,000 square feet in area and with a shorter side measuring at least 48 feet?
Yes, sir, as originally plotted.
And is it your view that you have a view one way or the other, whether, except as you just provided, and subject to any conditions of approval, that the partitioning of the existing lot does not otherwise create a nonconformity with the zoning code?
I believe that to be true.
Okay. No, yeah, you can do it.
Is there anyone here from the public to speak, to address this application? Seeing none?
We have one more.
Sir, may I ask, may I present my client just for the purpose of confirming that I've given no misinformation or misstatements during the course of this presentation?
Yes, sir. Thank you.
Would you come forward, please?
Anyone else? Oh, yes, ma'am. Please come forward and state your name.
Michelle Reckert,
Yes, ma'am.
And your address, please, for the record?
10 Columbia Avenue, 1012 Columbia Avenue,
And where do you actually reside?
in Cary, North Carolina.
This record, I think you're about to be sworn.
Yes.
Or maybe, perhaps not. That's
yes,
your
yes,
your
we will.
pleasure.
Yes. Do you swear and affirm that the testimony you'll give here today is true to the best of your knowledge and belief?
Yes, sir.
All right. Please go ahead.
Ms. Record, you're a co-trustee of the Yates Family Trust, correct?
Correct.
And you've been here during the course of my presentation and heard me make a number of factual references during this application,
Yes.
during this proceeding. Can you confirm that those statements are true and correct to the best of your knowledge?
Absolutely.
Is there any statement of mine that I've made factually that you wish to clarify in some way?
Everything has been true,
Thank you.
stated, truly stated.
That's all I have.
Thank you.
Oh, sorry. Yes, everything is true and stated, correct.
Thank you.
And who was the other acting co-trustee,
My sister,
and her name?
Beverly Walter.
Ms. Walter is identified on the certificate of trust and the application materials as well. She's a resident of what state?
Connecticut.
Just one other question, again, just for the record.
yourself.
The lots that you are seeking to partition were consolidated previously, do you know when or under what?
So I don't think this is speculation on
Yeah.
my part because I don't know when exactly the house was built, and maybe Michelle.
Well, my grandfather purchased it, I believe, back in the 30s. It was a bungalow and always thought double lot, and it's gone through three generations, basically.
So when my chain of title, or what our searcher found was 1945, that somebody named Stout, I believe it was, conveyed the property to Harry Fair.
Very fair, my grandfather,
Your
correct.
grandfather. So, but when your family came to own the property, the bungalow, as you called it, was already there, right?
The bungalow was there, correct, correct.
So I would
Is this a
submit
merger by use?
that would be exactly, stated very succinctly. I think that's what.
And it's taxed with one tax number by the county?
It's not one of these very rare situations where you've got two parcels that are recognized by the city and only one recognized by the county. This was only treated as one parcel by both governmental entities.
All right. Thank you. Any other public? Thank you, ma'am, if you're finished.
I'm done, thank you.
Okay, thank you. Anybody else? All right.
May I just add one quick comment? A question was put to the building inspector as to whether or not there was any discussion or consideration that he was aware of, that there was a enforcement action that was pending, and he said none has been commenced at this time. I can tell you that the subject has come up in meeting after meeting after meeting, and Mr. Burns has entered the room since that question was put to the building official. I think it's fair to say that there's never been expressed any intent to enforce this provision under these circumstances, and that there's really this is not a precedent-setting event, as I indicated before, because no one who comes before you in the future is going to be able to say that they had an application that was in force prior to the effective date of an ordinance which prohibits agreements such as that. So this is a very much a one-off situation. I certainly wish that this condition didn't exist. I wish we weren't spending this time on this. Naturally, I think you do as well, but I don't think anyone on behalf of the city would indicate that they are terribly troubled by application of that provision to this subdivision application.
All right, sir. Anyone else? Do I have a motion?
I'll make a motion. I'd like to make a motion to approve petitioning application number 0224-01 for the petitioning request of the property located on lots 10 and 12, Columbia, tax parcel map 334-1409 to 161. And to note also that all conditions in the building inspector's previous report have been met.
Is there a second?
Second.
I'd like to offer an amendment.
All right, ma'am.
I would like to amend the proposal or the motion to add a condition that the Planning Commission approval not become effective or final until such time as there is no contract of sale pending. And with respect to that, and with all due respect to you, Mr. Townsend, I think if this were a court of law, which of course it's not, but it is a public hearing, most of what you have said this afternoon has been in a position as a fact witness for recounting to us conversations, messages, emails, whatever, with the city on a variety of related subjects, none of which are in the record. What we're really here to decide is whether this commission should approve this application while a contract of sale is pending, which is a violation of law, at least given the words on the page, of 236-5 and the Planning Commission's own petitioning application instruction sheet.
All right, is there a second to the motion to amend the motion? Anyone? Okay, the motion to amend dies for lack of a second. As to the original motion to approve.
Do roll call? We're going to do roll call?
Was there a second?
Yes.
There was a second. Earl seconded.
Yep. Any further discussion? Go ahead and do a roll call vote.
Okay. Commissioner Strange?
I have to abstain.
He's abstaining. Better if I have the list in front of me. Commissioner Ellison?
I vote for. Do I need to provide reasons? Yes. I just think that this case is rather straightforward and simple and makes sense.
Commissioner Gay?
Oh, I vote in favor, and I agree with what Commissioner Ellison just said. And I also like to thank Mr. Townsend for reminding us that those application papers need to be updated.
Commissioner Stockdale?
I approve.
State your reasons, please.
I am satisfied the conditions have all been satisfied, and that there was no intent obvious to evade any requirements with respect to the pending ordinance.
Commissioner Dewey, myself, I vote in favor of the application. I believe that the applicant was very forthcoming regarding the specialized circumstances of this, and the record provided by the building inspector is clear that this is warranted. Commissioner Davis?
I vote no for the reasons that I stated when I proposed the amendment to the motion.
And Commissioner Bryan?
I vote in favor of the application, and I think the equities are just in your side. We're not a court of equity, but that's where I come from. And so I think what's fair is to approve it.
Thank you, sir. And thank you, members.
The effective date, or the effective date of the resolution that was just passed will be when a written resolution conforming to the vote that was just decided is issued hopefully early next week. Okay.
Thank you, Mr. Mayor.
Thanks.
All right, the next on our agenda is Mr. Robertson. If I may ask the building inspector to give the introduction to it, it may move things along. Yeah. Mr. Janis, you remain under oath for this application.
If I must, sure. Thank you, Chair. Would you like me to read the entire report or just the special pieces?
The highlights that, as you described in the last application.
No problem at all. This application number 1223-08, it's to partition lots 52 and 54 of the Rehoboth Beach Camp Meeting Association subdivision. Current tax map parcel number is 334-14.17-43.00. This application is to partition 2 lots located in the R1 residential district that are a 100 by 84 parcel currently. So we would be creating 2 50 by 84 parcels consisting of 4,200 square feet each. The applicant did apply for and receive a Board of Adjustment variance, application number 1023-10-10, to allow the encroachment of 0.4 feet over the front portion of the building, and let me make sure that that's correct. Look at my survey. Yes, so it's 0.4.
Oh, might just reference whatever the Board of Adjustment decision was.
Right, it was because the building sits not square to that side setback, it's 0.4 at the front and 0.2 at the rear, provided that the applicant removes existing porch, and existing screen porch and existing deck. Again, the applicant shall also remove the shed existing to the southeast of the property as the accessory structure. It would not be permitted without the accompanying main dwelling use. One condition that I specified in my letter, should the Planning Commission grant approval, a condition should be set that the structure is modified as proposed. Once the modification has occurred, the Planning Commission may then require an inspection and further documentation to show that the conditions have been met and that parcels may be created. That's the gist of my report, and I'm more than happy to take questions.
And is that still the case with that lot, or has anything been done on that since then, or those conditions still apply?
Nothing has been done to the parcels quite yet, to the parcel.
Okay.
All right. Any questions of Mr. Janis at this point?
Thank you, Commissioner.
I'll just ask the same types of questions that I asked on the prior one, and probably for the other app. Just, again, trying to just create a clear factual record for this. Does this application propose to partition lots to their originally plotted configuration as shown on a legally created plat recorded in the Sussex County Recorder
Yes.
of Deeds? In your view, does it meet does the application meet the definition of a partitioning under 236-3?
I believe so, yes.
Do you know if the applicant has paid the applicable $1,400 fee?
My records indicate that they have.
And I think you stated the lot is located in the R1 residential district?
Correct.
Again, I'm going to go through the same series of questions as before. Is it your view that but for the requirements of Section 270-22A of the City Code, it is not necessary to consolidate the partition lots to comply with the provisions of Chapter 270?
Yes, that's correct.
And is it further your view that each of the partitioned lots or proposed partition lots as originally plotted conforms to the requirements of Section 270-22A3, that is, each partitioned lot can fully contain within it a rectangle of at least 4,000 square feet in area, and with its shortest side measuring at least 48 feet.
I believe that to be true, yes.
Are you aware of any other nonconformities other than what you just testified about regarding compliance with Chapter 270 of the code?
Other than the ones stated, no other nonconformities were noted.
And are you aware of whether the Planning Commission has previously denied any subdivision application regarding this lot?
I believe there is reference possibly in the 80s. I don't have record
But
of
not in
it.
the last 12 months?
Correct.
Any other questions of the building inspector? Okay, Mr. Robertson?
Thank you. My name is Vince Robertson. I'm an attorney with Parkowski, Girk, and Swayze here in Sussex County and also Newcastle counties. This is a continuation of the prior public hearing, unlike the prior one. I don't have to start from scratch on this one because most of it was in the record. I would like to say at the outset, there's no contracts on this property that I know of. So hopefully this will make this shorter and sweeter. We did go through the information. So what I'm going to do is just put the survey up there. I think that's the most relevant. We went through the lot dimensions, and we went through the history of the property, the fact that the city taxes this separately and has for decades. There was a question on the last application about how the properties came to be one. I'm not sure about that, but the deed into the predecessors and title to my clients references in what we call the recital to that deed, a 1926 conveyance and a 1943 conveyance. So probably sometimes in the 40s is when this property became, owned by the same person, although it apparently was taxed by the city the whole entire time since that. We got a little bit sideways on this based on the discovery that there were some prior proceedings in the 80s. And as I told Mr. Mehta, as much as I wanted to talk about something that happened when I was a junior in high school, I think that all becomes moot at this point based upon the city's recent legislation. I will say, looking through that, there did not appear to ever have been a final determination by the Planning Commission for what it's worth. The Board of Adjustment back in the 80s was less than detailed in how it came to its decision. But when you look at that sort of thing, you also have to look at, well, is the code still the same? And until you all initiated that code change with the Board of Commissioners, which I appreciate because I think that clears up a lot of things in the city and for my clients, we were prepared to go through all the changes in the zoning code that had happened since the 80s, and there were a lot. And the one that's the most relevant in this case is the 4,000 square foot box that came into place since the 80s. So with that, I do have here today with me Chip and Jane Andre. Ms. Andre wasn't here last time due to a funeral, so she is here this afternoon. As I mentioned, the city's always created this as two lots. What you have on the screens is the survey. As I think Mr. Janis answered in response to the questions, it is two pre-existing lots, Lot 52 and Lot 54. You can fit a 4,000 square foot box inside of each one. We did go to the Board of Adjustment to get the variance for the encroachment of the house, understanding that the structures that encroach across the lot line, the deck and the porch, as well as that shed, would have to be removed to comply with that new lot line, or recognizing the existing lot line, as well as that Board of Adjustment variance. Both lots have 50 feet of frontage. They're 84 feet deep, just like every other lot on this side of the street. The FAR is compliant. Again, the existing dwelling, particularly with the removal of the screen porch, is well below, and the other one will be vacant. Same thing with lot coverage. And the setbacks, again, with the Board of Adjustment's approval, will be all compliant with the code. There will be parking on Lot 52 if and when a structure is ever built there. The parking for Lot 54, as we mentioned before, is going to be relocated to the front of the house. And as I said before, tree preservation, Lot 54 is fine. Lot 52, again, that will be complied with at the time, if and when it ever happens. There's no plans now to build or do anything with that lot. But whenever somebody does, it will have to comply with the tree survey as well. And as I pointed out, I think last time, when you look at this, most of those large trees are along the perimeter anyway, so there's a good chance that they would be preserved since they're outside of the setbacks on Lot 52. So with that, you know, I don't really have anything else to add because I think we covered it all, but for that question about the 80s documents, which is now moot, and whether or not we could utilize that 4,000 square foot requirement.
Well, that was really the key, is to get
Yeah.
that language put back in the code.
That's right
Yeah.
with these. So I think it returns to the code what everybody originally anticipated we could do. So.
I have a timing question. It might be for the building inspector, but, so the conditions from the Board of Adjustment have not been met yet with removing the existing deck and screen porch.
That's correct.
But am I right that the prohibition against demolition in the summer is for structures that are over 750 square feet?
Yes.
So could they demolish this in the next 3 months because it's less than 750 square feet?
That's correct. All
Okay,
it would require was a building permit.
Okay, which is good, because otherwise they might have to come back for an extension, either to us or the Board of Adjustment, so I was just kind of getting to that, but that sounds like it's not an issue.
No.
Okay, wonderful.
That's actually an informative question, so thank you.
Mr. Robertson, two questions. One is, I mean, the Board of Adjustment decision from March 8, 2024 speaks for itself, and that can just be incorporated. But can you just, my reading of that Board of Adjustment decision was a little bit different than the building inspector. So what is the variance, in your view, that was the encroachment that was permitted?
Well,
Because either we'll just reference the Board of Adjustment decision, or you guys need on the same page, so one or the other.
just as soon reference the Board of Adjustment decision, because it talked about a couple different things. It talked about the 0.2 feet to the 0.4 feet. It talked about the square footage. I think this is a document that hasn't been appealed. I would just as soon refer to this in the record.
And then, do you intend to either proffer or call a witness regarding whether the applicants are in fact the owners of the existing lot? That'll be a necessary
Well,
fact.
I was going to call them up just to
Okay.
confirm what we
Perfect.
said.
Thank
So,
you.
Mr. Andre, if you want to take the stand. And if you could state your, well, I guess first get sworn in.
Yes. Do you swear and affirm that any testimony you give here today will be the truth to the best of your knowledge and belief?
I certainly do.
Please state your name and address, sir.
Charles Andre, 54 Kent Street, Rehoboth Beach, Delaware.
Thank you. Mr. Andre, are you one of the owners of this property?
I am,
With your wife who's sitting there to your left?
to my left.
And you've heard everything that I've stated this afternoon, still this afternoon. Do you agree with all of the representations that I've made to the Planning Commission, not just today, but in the prior hearing as well?
I do, we do.
Thank you. Unless there's any
other
questions, I don't.
Any questions of the applicant? Anyone else? Thank you, sir.
Thank you, sir.
Are you concluded with your youthful presentation?
I surely hope so.
Yeah. Is anyone from the public here to address this application? Seeing none? Is there a motion from the Planning Commission?
Want to make one?
Yes. I move that this application be approved
Okay.
with whatever conditions Mr. Janis says he needs to have completed.
Second,
Is there a second?
yes.
Mike
All right.
Strange.
Any discussion? Mr. Dewey, call the roll.
I will call the roll. Commissioner Gay,
I vote aye. I think with the resolution of that code language, it's pretty straightforward, and so move forward.
Commissioner Dewey, myself, I vote in favor. All of the stipulations according to code have been met, so this needs to be approved. Commissioner Stockdale?
I also vote to approve. I think all the conditions of the code have been met, and no nonconformities exist. Thank you.
Commissioner Ellison?
I also vote to approve. I believe that everything that I've heard, everything seems to be very much in order. So I'm very much in favor of it.
Commissioner Davis?
I vote to approve also for the reasons that have been previously stated by my fellow commissioners.
Commissioner Strange?
I vote to approve, and based on all of the comments that my previous commissioners have stated, I'm in agreement with.
And Commissioner Bryan?
Yes, I vote to approve. For all the reasons already stated, I think it's a great application. Thank you.
Thank you very much. And I had that up on the screen. We do plan on sending that letter to the Rehoboth Beach Museum that said, on what basis and upon whose imagination the city arrived at the value of $47,000 for the value of that property. So, which is a fantastic letter. Thank you very much.
Next matter on the agenda. Do we need a break? Before we
I
get
just need a
going?
minute or two just to.
Yeah, so
Let's
let's,
take a, we can take a 5-minute.
5-minute break. We'll adjourn for 5 minutes. Let's reconvene, please.
I don't think they heard you. Are we back on, Ann? Okay, we're back on.
Okay. Let's reconvene. Okay. All right, we're back in session.
Talk about, well, I said this to this one, and he said that to me.
The next matter on the agenda is the 413, 415, 417 Rehoboth Avenue public hearing and site plan review, I'm sorry. Mr. Robertson?
Thank you. I'm still Vince Robertson with the law firm of Parkowski, Yerk, and Swayze. And I know that pretty much I'm the one standing in the way of everybody's happy hour and dinner plans on a Friday afternoon. So I'm going to try to expedite things in a couple different ways. One thing is, we've had the concept review hearing, we've had the preliminary review, and now we're at the public hearing. There's been a lot that's been said in those prior two, particularly about the comprehensive plan and the city's architectural guidelines. If I could, I would like to just incorporate what's been said, particularly about the comp plan, and that's referenced in the city's report, as well as the architectural guidelines, to avoid having to say all that for the third time. I'm willing to do that, but I think we could just incorporate that into the record.
Yes. All right, you're going to make all that part of the record?
If I could, yes.
Yes, please do.
Yeah. So if I consider it incorporated at this point, thank you.
Yes.
The other thing is, at this point, we all have seen the building and licensing reports for dated March 8, 2024, issued jointly by Mr. Janis and Wallace Montgomery. And there's three of them, and they're fairly detailed. I'm fine so that we don't have to go through each one with stipulating to those reports and the information's in there, so Mr. Janis doesn't have to either read or summarize those as well.
Yes, they are each dated March 8, 2024, is what I see. Is that correct?
March 8, 2024, yes, sir, yes.
All right, so you're making those part of the record?
Okay. And obviously, the site plans and everything else are part of the record already, or we wouldn't be here this afternoon. I do believe there's one person that has a time issue that would like to speak, and I think that's Ms. Lovett, because of the prior commitment, and with your willingness to accommodate her, I know we all want to be somewhere, but I think she has a particular time constraint she's dealing with if she could speak.
Yes, sir, please have her come forward.
Ms. Lovett? Yeah, and she's not a witness of mine, she just approached me during the break asking.
Hello, everybody. I'm a little short.
No.
Can you, okay.
We have to be sworn in
Thank you,
first.
Matt. There we go. Now we broke it. Thanks. Hi,
Okay.
Cindy Lovett, 4 Canal Street. I live about a block and a half from this project. Oh,
May you please state that you swear and affirm that the information, the testimony you'll give here today will be true to the best of your knowledge and belief?
I do.
Thank you.
Okay. Again, Cindy Lovett, 4 Canal Street. I live about a block and a half from this project. And I have to tell you, I think that there's absolutely nothing that's perfect that goes anywhere in town. We all know that. But I think that this concept is really, really one of the best things I've ever seen. I love that the houses aren't cookie cutter, each of the buildings. I think it kind of represents, 2 of them kind of remind me of the old tent houses. And I love that the owners here have kind of reached out to that design. They aren't built out wall to wall or, setback to setback. I'm really hoping this gets approved. I really would be very sad if it does not, because I can't think of anything else better that could go in that spot. The retail and commercial part of town is, in fact, moving west. So I just think that this is a great idea. I have never seen more than 2 or 3 people in virtually any retail store in town, other than maybe Browse About. So I can't imagine we're going to have, 24 cars at each of these little locations. It also could make a great office for somebody. So as a very nearby resident who walks past this thing constantly, this property, I really support this. And I hope that we can let it pass, because there's a whole lot worse things that could go in there. So please, 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 I hope that we can approve this project and in a timely manner. Thank you very much.
Ma'am, thank you very much.
Okay. Thank you, and thank you for accommodating.
Yes, sir.
Ms. Lovett. So with that, just by way of introduction again, I'm here today with Dave McCarthy, who is the the owner and builder of this project. We have Jeff Scholkoff here to my right. He's the architect of record with Design Group. He is familiar with Rehoboth Beach and has designed many projects in town, including 48 Wilmington Avenue, which we talked about before. He's, in that regard, familiar with and has applied the zoning code on multiple occasions here in town. And in fact, several of his designs were actually used as favorable examples during our review of that architectural guideline summary that the city developed. And then I'm here with Roger Gross as well to my right, who is the professional engineer involved in this project. I thought the first place I would start is in the guidance that your code gives about site plan review. There's some criteria to consider for site plan review. The first is the protection of the architectural massing, composition, scale, and character of the neighborhood. And in that respect, I'm not going to reiterate it, but I thought Wallace Montgomery and Mr. Janis did a good job of summarizing the comp plan compliance in their original review dated August 25, 2023, talking about multiple goals of the comprehensive plan that were satisfied. I won't read those, but it's goal 3.1, goal 3.3, goal 4.3, goal 5.2, goal 5.3, and goal 5.5. The biggest one is talking about redeveloping or improving commercial properties and commercial structures, particularly along Rehoboth Avenue, and looking for the appropriate scale and design that's compatible with the city of Rehoboth Beach. So, based on what the comp plan says, the architectural massing, composition, scale, and character of the neighborhood is improved with these three structures. As Ms. Lovett so adequately said, they do maintain the beach house look, really the original old beach cottages in Rehoboth Beach. That was the design that was strived for. It's certainly better massing, composition, and scale than what currently exists, with the exception of Weath and Home, which is next door, which is a retail structure. We have, if you're facing this, we have the Arc, which is a giant concrete box of a building that doesn't have really any good kind of massing, composition, or scale. No offense to anybody who might have a unit in the Arc. And then we have to the left of that, or the west of that, on the other side of Weath and Home, the Royal Farms, and then just next to that is another two-story block structure, which has a laundromat and a nail studio, I think, in the basement. So, really this is, I think if you said it was compatible with that, it would be underselling these, frankly, because these are much nicer than with the exception of Weath and Home, what's there. So again, the next one, number 2, is compatibility of the new construction and structural alterations with the existing scale and character of nearby properties. Again, this is not compatible, but in a positive way, since it's really more compatible with the overall design character we want for Rehoboth. There's a preservation of streetscapes. Again, those streetscapes will be preserved and enhanced with the inviting, pedestrian-friendly front porches and the open area in front of each of the structures, and also the open area along the right-of-way, which is particularly wide there. And again, this is a better preservation of the streetscape, or a better enhancement of the streetscape, however you want to say that, than frankly what could be built there. Keep in mind that these are now 3 50 by 100 lots. They could be one 150 by 100 lot, which you could build a commercial structure on that covers the whole thing with 0 side yard setbacks and a 2.0 FAR. In terms of the streetscape, this is, I think, something that's much more attractive than that, and preserves it and enhances it. Protection of natural resources. Unlike that commercial structure we just talked about that could have 100% lot coverage and 0 setbacks and cover the whole thing, there is green space, there is tree preservation on the site, plus the HVAC system, sort of looking at natural resources on a larger scale. It's going to be geothermal, which is a green technology. So in terms of protection of natural resources, that hits that mark also. And then the 5th one is the protection of the public's health, safety, and general welfare. That's one of those that's sort of nebulous. It can mean just about anything to anybody. But we do feel that for all those reasons, including the suggestions put forth in the CDP as well as those architectural guidelines, that 5th element will be complied with, or is complied with. We sort of touched upon this, but these 3 projects are also at a significant location in the city. They're right at the entrance, as we all know, just past the Circle and the Lighthouse. It's one of the first things that you'll see coming into town, which sets the tone and the theme for the town's architecture in a positive way. And it's one of the last things that you'll see leaving town, which also creates positive memories as you're leaving Rehoboth Beach on Rehoboth Avenue. It will also have a positive economic impact on the town. We talked about this before, but there'll be somewhere around $90,000 in building permits generated by the construction of these three structures. There'll be increased property tax revenues versus the vacant lots that sit there now. There will be additional business license fees. And also, this will have a benefit to that end of Rehoboth Avenue and the city in general with an enhancement and sort of it'll draw more people down there. You know, we have, as I said, we have a nail studio, a laundromat, and a Royal Farms, which isn't necessarily drawing, you know, our tourist community to that end of Rehoboth Avenue. Other than Weath and Homes, you know, this will add 3 more nice upscale retail establishments to that end of Rehoboth Avenue, which is frankly good for that end of Rehoboth Avenue. Hopefully foster more businesses there and the business licenses and make those properties more valuable to the property owners and the citizens. And that's actually reflected in a letter that's in the record from Dr. Robinson, who wrote in support of this. He owns the property where Weath and Home is located and is in support of it. His area of concern was the lime tree, which is a crepe myrtle, on his eastern boundary, which is our western boundary, and wanted to make sure that that's going to be preserved. It is. It's on the side of his driveway, and it will be on the side of the driveway that's been proposed all along for that side, for that particular lot. So there's that. The other, while we're talking about letters, just to kind of keep rolling through those, the only other item of correspondence was one from a Mr. Louder. And since now's the time to answer those questions, or, you know, or address it rather than maybe if it comes up later, I just want to, he raised a couple of issues. One was, and I understand he lives behind, or his property, I don't know if he lives there, his property's behind the eastern most of the 3 lots. One of the things that he raised was the 5-foot setback to the rear of our property. Keeping in mind that our properties are zoned commercial, his is residential. There's a 0 lot line setback in commercial unless you're next to residential, and then it triggers a 5-foot setback on that common boundary. In this case, we exceed 5 feet in each case, and you know, so that's what the code says. That's what we comply with. You know, actually, we exceed that, as I mentioned. It's not just right on the 5-foot line.
So what is the measurement? It looks like I'm seeing 6 feet 10, is that right? Or something, or 5 feet?
We'll get Mr. Shilkoff to go through that when he shows it, because when you look at it, each one of them, like the westernmost is a little bit wider, and then the middle one's 7, and I think with his it's 6, 7 without looking at it. Yeah. And then there's another mention that talks about the dimensions between the property line and the decks up top. So, but we'll get Mr. That's a fair question. We'll get him to answer that. He asks about screening and what's proposed of fence and trees. Well, there's fencing there now, and there's trees there now, and certainly we're going to comply with all the tree requirements and, you know, take care of that. The third one is upper level porches. He's asking that they be constructed or screened so that they do not have a clear view into our backyards. With that one, you know, we comply with the setbacks for the, you know, those decks up top. These are 50, we live in 50 by 100 lots in the city of Rehoboth Beach. You know, you could build a house today that would have the same issues, perhaps more so. I mean, from personal experience, I've got a house going up next to me that, you know, somebody looks down into my outside shower on and had to reconfigure that. I mean, that's just part of the deal of living in Rehoboth Beach. Anyhow, you know, we comply with that. The code establishes what that is. I don't know how we address that any further. He does have an issue about HVAC systems, and as I mentioned, and I think he's assuming there's going to be outside condensers or whatever stuff that makes noise. As we said before, that's not the case. It's geothermal, so the mechanical will all be interior. And then the last one, and this came up a question before, is he says, I hope the commercial spaces are not designated as restaurants. So first of all, they're not designed as restaurants. They're intended to be used as retail. I mean, that's the plan. But just, and I hate to say this because people are going to think, well, look, they're thinking about it. But just for the sake of argument, if anybody's concerned that a restaurant would go in there, This is not the end of the story if it's a restaurant. Well, for one thing, there's talk about changing the code and whether a restaurant would have to come back. I don't know how that's going to end up. But regardless of that, any restaurant has to get a permit of compliance from the Board of Commissioners. And that requires a public hearing where there's notification and anybody would have an opportunity to speak. And two of the relevant criteria that the permit of compliance process considers at the Board of Commissioners is whether the establishment would be a detriment to the peace, order, and quiet of the neighborhood of the city. So, we can talk about design things at that point, in terms of where they're putting dumpsters or whatever. And whether the establishment will have an adverse impact on the neighboring properties on the city of Rehoboth Beach, considering the impact on traffic, parking, and noise. Again, that's with respect to a restaurant. If a tenant said they wanted to do a restaurant, then they would have to go to the Board of Commissioners to get that approval. That's one hearing, in addition to going to the Alcoholic Beverage Control Commission after being noticed to have a whole nother hearing on that. So the point being, there's not any plans to do a restaurant. And even if at some point, who knows when, somebody wanted to do that, there's still protection for the neighbors because they would have an opportunity to participate in that process. So, and I should back up. I want to make one thing clear from my presentation. For everybody here, I'm not going to say this 3 different times. We've got 3 projects. Mr. Shulkoff's going to go through each building separately, but the background applies to all 3 at the same time. So I just want to make that clear. So with that, one of Mr. McCarthy's goals, as we said before, was to, I think his comment was, I wanted to avoid the drama of what we've seen before on this property. And he wanted it to be code compliant from day one. And in that regard, he had seen 48 Wilmington Avenue. He had met with Mr. Shulkoff, who designed that. And in a moment, Mr. Shulkoff will describe his meeting with Matt about 48 Wilmington, not in a whole lot of detail, but the question was raised before, and he designed that, and he's going to talk about briefly his meetings on these 3 properties to make sure that the whole thing is code compliant, which of course is reflected in Mr. Janis's and Wallace Montgomery's report. And as we know from Mr. Janis's report, as well as the Wallace Montgomery reports, they've determined that the properties are code compliant. The only thing that they mention in bold red text on any of the 3 was about signs, and we know that that's a future issue at some point. It's going to depend on whoever the tenant is. So, again, Wallace Montgomery reviewed it, signed off on it, and what we think we have are 3 attractive code compliant structures that are an asset to Rehoboth at a prominent location in Rehoboth that are much better designed and scaled than what could be built there as, one great big commercial structure or 3, frankly, great big commercial structures. I think as Ms. Lovett said, it's some of the best looking commercial structures we've seen in a long time come through Rehoboth. And again, I think it's significant that they sort of set the tone for what somebody will see coming into town, in terms of what and I know this sounds like an opinion, but what we like to see in Rehoboth Beach in terms of sort of the classic beach cottage structure for the city. So with that, what I'd like to do is turn it over to Jeff, if you want to come on up. Hi, everyone. Yeah, let's do this. Hold on, give me a second. Technology here.
I'd like to make one point of clarification. Can I do that now?
Before he begins,
I just want to make one point of clarification. You talked about the building inspector's report and Wallace Montgomery report. There were actually 2. There was one initially in November when you all came for concept, and it was a result of that concept meeting where there were some nonconformities found in their report then and in our discussions then, and then you all went back and changed the designs accordingly so that the report you're referring to where they agreed to is the March 8th report, which reflects our interpretations and our discussions in November. I just want to make that point, that it was revised based on our...
Yeah, no, that's true. And we kind of had things happening simultaneously. I think that report was issued at the same time they were revising plans, and then we went to preliminary or whatever, so, yeah, our concept review. But you're right.
You want to swear me in, I can
Please.
respond additionally, so.
Do you swear and affirm that the information and testimony you're about to give today is true and correct to the best of your knowledge and belief?
Yes, sir.
Before you do that, I have some questions for Mr. Shokoff just before we get to that.
Can I say one specific thing about
Sure.
her question? There was a previous step also where we, before the preliminary report with the red, we had gone 2 or 3 times to Mr. Janis. We had gone 2 or 3 times to Mr. Janis in the 3 or 4 months before that, and there was a report that, a letter that we received in July of 2022 that outlined a whole bunch of other stuff that we worked on. So this was a continual process of working together to try to do diligence, to try to bring forward a compliant project.
Yes, sir. Would you please give your name and address for the record?
Jeff Sholkoff, I am P.O. Box 237, Warren, Vermont.
Thank you.
Did he get sworn in? I apologize.
Yes, sir.
Okay. Just wanna make sure.
I just haven't sworn you in yet.
Never mind. Mr. Sholkoff, if you could just state your role and responsibility for the record with regard to this project.
Yeah, just planner and architect.
Okay, and the name of your firm?
The Design Group, JSD Incorporated / the Design Group.
Okay. And again, you saw this happen in the prior hearings. You've heard everything I've stated to the Planning Commission. Do you agree with everything that I've stated so far?
Yes.
Okay. And how familiar are you with Rehoboth and generally with regard to projects you've done in the zoning code?
Yeah, those were 2 different questions.
All right, well.
Rehoboth, I started sweeping miniature golf holes when I was 12 on a rooftop over Ryan's. But as far as architecture, you know, I've done projects for the past 35 years here. I did the Moore Building, I did the South Quinn Under, I've done the Avenu Inn, and a number of other projects in the area. So,
okay. And was one of those 48 Wilmington Avenue?
Yes.
And was, you heard me say, but was 48 Avenue the origin for these projects?
Correct.
Okay. And
Mr. McCarthy looked me up because he wanted to do something like that. I got a call that said, "Are you the architect?" That's what led him to me.
And did 48 Wilmington Avenue go through the same sort of design review with the building officials and city staff?
Yeah, I mean, our typical process is we do diligence. First thing we do when we get hired to do something is we try to meet with fire marshal, building inspectors, zoning administrators, sometimes health department, other people, whoever we need to try to sort things out and understand the lay of the land. In this case, you know, I'd done a lot of work with Mr. Janis's predecessors on the Avenu Inn, and then on, I guess, it was around the time we were doing Cooper Cottages too, that was coming in. And anyway, it's an ordinary process. We do that vetting. I think it was 48 Wilmington was the transition. There were notes I had from meetings in June of 2022 that were with both Mr. Janis, Mr. Molina, and Ann, where we all sat down and we were vetting the rules.
Was that 2022 or 2018 for 48 Wilmington?
For 2018. Okay. Sorry, right. Getting my years mixed up. Yeah.
So fast forward then.
Because 2019 was construction on that one.
Okay, and that's obviously built and a C of O has been issued?
Correct.
Okay. And just for everybody's benefit.
And I think you showed you had found the plan with the seal on it that when it had been approved.
Yep.
I believe you showed that into the record last time.
There we go. It's just that for the record. And so fast forward, Mr. McCarthy, he asks to consult with you. I assume Mr. McCarthy didn't have anything to do with 48 Wilmington at all.
Correct.
Okay. He asks to consult with you. He wants you to design a project that obviously looks nice, but also complies with 48 Wilmington. What did you do next with Mr. McCarthy and the city?
Well, it just had a similar, there were a number of influences. I mean, this was one of them, but the program was about the same. I think Mr. McCarthy's vision was to do these 3 lots separately, to have commercial on the ground floor and an apartment above. So the program was so similar, but also they showed me many other references, some of them in Lewis, some of them up in New England, some of them in Florida, and the team at Mr. McCarthy's office had a number of influences. as we developed options and grew towards this, they wanted the things that have been spoken about today, which is the variety of the three being different. And I had done a few studies for some other things, but we sort of modeled, the cottage with the shed roof on the front, the gable face thing, and the hip roof, and we kind of said, let's do one of each, and we played around with them up and down the street a little bit and came up with an arrangement that we thought was kind of attractive and had the open space between each one and all.
And does 48 Wilmington comply with the same setbacks and lot coverage and FAR and height calculations as the three?
So, yes, but. So
Right.
I believe the rules were fundamentally the same. The interpretation was a little bit different, and what got redlined in the report, I don't have the dates right in front of me, but the previous report that had more red on it, the two items that came up significantly were not being allowed to have the second level deck, outdoor deck in the setback. At 48 Wilmington, it was allowed. And having to have the rear yard setback applied fully to the screen porch. Okay. So we did two things. The height was interpreted the same. The interpretation of the top floor being a half story by being 50% of the area of the floor below was the same, and the setbacks. Oh, and I guess the big one was the side yard setbacks, where there was an interpretation at 48 Wilmington that we were 6 feet minimum, 16 feet total, and I think when that was looked at by Wallace Montgomery, they picked up some interpretation of the code that it was 10 feet minimum, 20 feet, and that's what it was revised to. So the determination that it's now compliant was a little bit different from 48. It was a little more restricted.
Okay, so it's actually more restrictive than
Yeah.
48. Okay. With that, I'm going to turn him loose on the plans because it doesn't do you all any help to hear from me on that. So if you would, I don't know which one. Oh. Yeah. Mr. Sholkoff, Mr. McCarthy has reminded me, if you could just elaborate on the times that you met with building and licensing staff, either if you have the dates, which would be fantastic, but if you don't, the number of times.
Well, it was 3 or 4 times, and then there were some phone meetings, but I did have specific notes of meeting first with Mr. McCarthy and Mr. Janis in November of 2022, then meeting again with Mr. McCarthy and Mr. Janis February 16th of 2023, and then we submitted plans in March of 2023 at first, had reviews with the fire marshal that caused a couple of tweaks to the plans in April of 2023, and then received Mr. Janis's report back, first report, the one I was talking about, in July of 2023. And then we had another meeting following that up to try to work out. Some of those points made in that one had more to do with civil engineering, and Mr. Gross got involved in doing the, addressing those at the time as to what needed to be done at this stage of development. And then I guess it was after that where the responses and some questions back and forth on the Wallace Montgomery report both times.
Okay. Thank you for elaborating on that. The point being that there's been a lot of work that's gone into this to get it to the point where, not even including the twice we've been before you all, to get it to the point where we're here today with a public hearing and hopefully a favorable outcome. So, Jeff, if you would, again, it looks like the plans are on the screen, so if you want to describe those.
Yeah, so again, that's,
and if you could identify which one you're talking about.
Right, so this one is 413. It's, I think that recognizing that you all have done 2 double headers here 2 months in a row, and you've had a big day yesterday. I'm going to be brief and ask you to ask me questions if you need to see anything, and try not to be too repetitive.
Thank you, sir.
I'm going to try to hit some of the questions that came up. So the question that came up on this one last time was where are the closets? Just, there was some question about that. I don't think I need to submit this for the record, but more to demonstrate that closets are feasible within this. We have every intention as we develop the architectural plans to put closets in. And in every bedroom, I've shown in a yellow box sort of where they would be. So if you need that for the record, I suppose we could follow up and submit.
Yes, please.
Yeah,
Okay.
We'll make sure that Ms. Womack gets that, just a copy of it.
Right.
And it just also because the question came up about the setbacks earlier on.
Yeah, so, and this is where it gets a little repetitive. So when we did the revisions before the last meeting that we had, between the concept review and the preliminary review, we had outlined this and I presented them last time, so I'll just go over them briefly again. So with 413, it was revised to comply the minimum rear yard depth, bringing it to 10 feet. Bringing the minimum side yard to 10 feet each side for a 20-foot aggregate. When we did the side yard, we also moved the ground level residential to the full 10 feet because previously we thought because it was coming in from the commercial level, it could be closer, but we pushed that over. And when I mentioned the 10-foot setback, that's to the residential. We still have the commercial taking advantage if it's allowed 0 lot line. And then the building height had a discrepancy of 1 inch. We lowered it to the 1 inch. And the FAR had a slight discrepancy in calculation that we revised to keep it under 2.0 total and under 0.6 for the residential portions, as is pretty clearly outlined in the code as a requirement. And those numbers are all on the plans. I would say, other than what I put in red, these plans are identical to what was presented before. So we haven't changed anything given the positive report from Mr. Janis and Wallace Montgomery.
And Ms. Gay had asked about the actual ground level setbacks, I think, to the rear of the property.
Yeah, only because I thought it was interesting when we got that letter from Mr. Lauder. I looked at the plans, and he seems to be concerned about the closeness of the structures to the lot line because he understands that only 5 feet's required, but there had been a previous plan where they were willing to do 10 feet, so he was asking about it. But I guess one of the things I looked at, which is good, when I looked at the plans, is it looks like there's going to be just a wall in the back, right? It's not going to be at the rear lot line. There's a window maybe in the restroom there, but other than that, that's it?
Right. The kind of back of the house of anything commercial will be back there,
right,
not the active side.
That's what I was getting at.
And the porch that would be, whether it's a sidewalk sale or a cafe, faces the street on the other side.
That's right, okay.
And,
Oh, I was going to ask about that.
Yeah, well, the garbage is tucked in down the side. There are totes designed for all these.
Okay.
And a way that you can pull them down out to the street. So, but they're not right in the back. They're all down the side.
And they're screened?
They're screened. There's a sliding door in front of them.
Okay, yeah.
To address the setbacks, they all did vary a little bit as we refined the FAR and refined all the setbacks. So 413, this one is the least, I believe. It's at 6'10" minimum, which is, I think, the number you were seeing.
Mm-hmm.
Although I would point out the residential portion is all 10 feet.
Oh, sure. No, I know that.
So once you're up above, it's 10 feet.
Right.
The commercial part below is 6'10". The 415 is 7 feet, and the one all the way to the west there, 417, is 10 feet, even down below. So it's all more than required.
Yeah, and just because we have 3 separate ones, we have to make 3 separate records on. If you could go through.
Yep, I was going to hit the other ones now then. So.
But again, I mean, you've already stipulated to the building inspector's report, including the building inspector's measurements for all 3 lots. So there's the testimony here is not going to contradict the building inspector's.
Since it's site plan review, though, we sort of wanted to go over the designs of it.
It's more just answering questions, explaining what we got, how we got to where we are. So as just a refresher, in the kind of more architectural, boring drawings than the nice illustrations, this is the looks, and that hasn't changed, and it does have the height pretty clearly delineated, and the limits of the height dotted, and the height that it actually comes to is about a foot below. So that's that one. And then on the middle one, 415, was the one with the hip roof. Same thing, we showed where the prospective closets would be in this illustration. This one was similar. We revised to comply the residential tier 1 uses being 10-foot rear yard setback. We revised the 10-foot side yard setback on the residential and included the roof decks and removed any area of roof deck within that 10 feet on each side. And we pushed the residential entries in so that they were a 10-foot setback. Building height was calculated at 3/4 of an inch over, and we lowered it to 3/4 of an inch by kind of narrowing the buildings. It kind of did it automatically. The FAR, again, the calculations stand as they were when we presented it last time at complying with 2.0 and the residential FAR complying with less than 0.6. And this one's significantly less because the middle building is pulled back a little bit to enable plaza in the middle. So of these 3 buildings, the 2 on the end push forward to the street a little bit more, and this one pushes back a little bit more, and then has this kind of, has a more of a plaza deck area, which is all within the setback. Okay, and then just, again, a refresher, the looks of this one are, this is the one with the hip roof, and when we pushed the stairs back in, it became a bit of a tower element, and then the front has the porch with the patio in front, and a kind of a glass porch up front on the upper level, on the residential level. Then on 417, 417 actually already had closets. Oh no, wait, it was the other one, 413 did. 47, no, it actually has them, I just highlighted them. So 417, it already said closet, closet, closet. And so I just highlighted them to see where they were. This is the one that has the 10-foot setback as proposed. And it's going to sound a little repetitive, sorry. The tier 1 uses were made sure that they were 10 foot on the residential level from the rear yard. The side yards were moved to 10 foot each side. The residential entry was pushed in to meet the 10 foot also. And in this case, there was a discrepancy in the measurement. I think this one, the measurement discrepancy was where was the center line of the street, not what was the height of the building from there. But we adjusted for that. And again, as it got that 2 feet narrower, it brought the roof down naturally. So it was deemed compliant in that last report. And then again on this one, the FAR was a little bit below the 2.0, and the residential FAR was just slightly below 0.6.
And this is the one with the location of the driveway that will preserve the lime tree that Dr. Robinson was concerned about. I know Mr. McCarthy was as well. Is that correct?
Correct. I think we have, I think we can pull this up and, how do I rotate it? I know this doesn't work like mine.
You can probably slide it up the top.
Okay. This one here. Yeah. I'm gonna have to go, if it goes this way, I got 3 times. Okay, so yeah, the tree that's under discussion is this tree here remaining, and our driveway comes in before the tree and preserves it in a tree well right there along the driveway.
And it's a crepe myrtle. Then I would advise you to get it treated as soon as possible for the crepe myrtle black bark disease that seems to be rampant in the city right now. You can save them if they're treated.
Thank you. Also helpful information.
Had to do mine.
And I would just reiterate the one item, and it says it pretty clearly on the plans, but we're all aware that the signs will have to come back in for a permit at the time the businesses are sorted out.
I have one other just minor tree question in addition to the preservation. Is there room on the lot, because this wasn't addressed in the building inspector report at the time, is there room on the lot for the 3 trees, or are you going to be paying a fee in lieu for some of those? Do you know?
If I can get, I mean, I want it to look beautiful landscape too, if I can get them.
Okay.
Yeah, I mean, we
Yeah,
have
the 3, just 3 are required, so. Okay.
Yeah, every each plan, I guess it's on the site plan. Yeah, each plan has the required trees,
Okay, good.
proposed landscaping, see general
So in the
notes. and I
back.
think that would be covering that
Okay,
requirement.
good.
It's, I think we're saving the trees along the street. There is this large right-of-way area that's angled there. I think the owners would probably hope to work with the council, the commission, and get permission to keep that green and enhance it. We didn't want to complicate these issues with some negotiation on that yet, till we know what we can do.
Great. Great to know they can be added. That's wonderful.
Thank you, Jeff. I mean, as he said, we don't want to belabor it, but if you have any technical questions for Mr. Shulkoff, we'll certainly entertain those. Candidly, that kind of concludes our presentation. Hopefully, it's really straightforward. This is just a good project for Rehoboth. Again, to use Mr. McCarthy's terms, it's one that hopefully doesn't create any drama, and it will be an asset to the city. And really, I can't think of an example that more squarely hits all 5 of those requirements for site plan review, and really nails it for the CDP, and also, I'm not going to pull it back up, but on the architectural design requirements, there was actually the sample of what the city wants to like that showed 3 structures, and except for them being out of order, they're the same 3 structures that has been proposed here. So with that, and just don't go anywhere because I might have questions, we'll entertain any questions.
Members of the Planning Commission, any questions?
That's okay.
Hearing none.
Okay, thank you.
Okay.
Yeah. Mr. Mehta has.
So again, I don't know whether these are maybe directed toward you. I might ask the same question again just to both of you, just for purposes of establishing the record. The property is located in the C1 Central Commercial District. Is that your understanding, Mr. Robertson?
Yes, yeah.
Mr. Janis, we'll do it quickly.
Correct.
And in your view, is this project a mixed-use project as defined by the Rehoboth Beach City Code?
So it's a commercial structure that has 2 different uses in it. It has commercial on the first floor and residential on the second.
So is it a mixed-use structure or not, in your view?
I don't want to define, because I'm not sure there's a real solid definition in the code for what a mixed-use structure is, so I'm just stating what it is.
Well, there is. So Matt, in your view, is this a mixed-use? 270-4 defines mixed-use as follows: as applied to buildings means the inclusion within a building of both commercial and residential use. So, Mr. Janis, in your view, is this a mixed-use building?
Yes, according to our definitions in 270-4, it would be a mixed-use building.
And Mr. Robertson, having been, your recollection having been refreshed on the definition of the code, do you believe it's a mixed-use structure?
So that's the issue is structure, because the definition talks about uses, and then there's also structural things. So, I mean, it hits the definition of mixed uses, and there's 2 different uses.
But it is one building, right? It's one building permit?
Yeah, that's the thing. It's absolutely one building permit.
Yeah. Okay.
With commercial on the ground level, which sets the tone for everything else.
Yep.
I'm not trying to be cagey. I just, I don't want to get.
Well, I mean, you agree that we need to review the site plan in view of the zoning code?
Yes.
Okay. And as I understand it, and I think the testimony today was that there have been some modifications to the drawings to address the setback requirements of the zoning code, which actually do differentiate between residential and commercial uses for purposes of interpreting the zoning code. And the question I have for, I guess, for you, Mr. Roberts, is more of a legal question than a factual question, is how do you propose that the city, and for present purposes, the Planning Commission, interpret the zoning code for a mixed-use structure in this case specifically with regard to height and lot coverage? We've asked this question before, and just asking you to address it again, please.
Certainly. I'll start with lot coverage, and Mr. Shulkoff, if you want to chime in on any of these. Once the lot's covered, it's covered. You can't uncover the ground once it's already covered. We could do 100% lot coverage for commercial. We're less than that, but we could certainly cover that. Lot coverage is measured at the lot or ground level. There's a decision that goes back a ways that we actually cited in response to our concept review. It was Clark v. Packham Associates that talked about, again, what I just described. And there's another section that talks about, again, just on the conversation we're having about mixed uses, it's 270, 21B5. Provides that for all mixed-use buildings, the average of the gross floor area of all residential floors shall not exceed 50% of the gross lot area, and the gross floor area of any one residential floor shall not exceed 75% of the gross lot area. So, with that, it says in the code that you can at least have 75%, which is greater than the 50% at ground level. So you can't read those consistently if you're going to say, that anything on an upper floor has to be limited to 50%. Again, once the ground's covered, it's covered. And we do comply with those averaging requirements. The height, as I mentioned, and I think Ms. Gay asked this, this is a commercial structure. It is one commercial building. It's designed to commercial building code requirements. We have both the building official and Wallace Montgomery's determination that the correct height is the 42 feet, and we comply with that. That's what we pay Wallace Montgomery for here in the city, to be the consultant to look at all that stuff. And there's a lot of both consultants are certified land planners. They know how to read zoning codes. In addition to Matt, they both agreed that it's 42 feet. The other thing is, it kind of, if with the height, we're looking at this, horizontally, I guess you would say, whether you have commercial on the first floor and residential above, and how do we measure that? We kind of focus on that, and it struck me as I was thinking about this, the absurd result of applying that would be, well, what if we had commercial next to residential? That wouldn't make any sense. Then you could build the commercial on the same lot, on 50 by 100 lot, that goes to 42 feet, and then you'd have the residential, same building permit that's lower. It just doesn't make any sense, particularly when it's all one building. And I guess the other thing is, why would we penalize these three smaller individual commercial buildings at a lower height when someone could come in and build a single commercial building, as I said, to 42 feet, to 2.0 FAR, with zero setbacks except for the rear setback across 1,500 square feet of lot area, or 15,000 square feet of lot area. So, the bottom line is, these are commercial structures. The officials who interpret the code have said, just like us, that it's 42 feet. And 48 Wilmington Avenue is the same way.
Yeah, I would add just a couple of things. One is that we
Please step to the microphone.
One is that we recognize fully that if there was just a single-family home built on these lots without the commercial, the height would be, it's clearly prescribed. The other is maybe we're getting a little too nitty here, but if you look in the sections under both lot coverage and FAR, they have a provision specifically addressing mixed use. If you look under height, it doesn't, and therein is the confusion, and I understand that, which is why we seek counsel from the authorities and the representatives of the town. But by leaving it not said, I would agree with everything that Vince just said, that we approached it as we did at 48 Wilmington when we were speaking with Mr. Molina, that on this type of lot, you should be able to go to the height, especially with such a tall building next door, too. There's all the other argument is all the CDP stuff and all the design guidelines, which talks about scale and character of the neighborhood, and you don't want to be even more dwarfed, I think, by the large building next door. I think you want something that has enough gravitas to hold its place on the street and be kind of a strong presence.
You got more on your list? You don't? Thank you for raising the issue about height, because that's one of the ones I know that we talked about extensively at the, and I've done a great deal of thinking about it, and I have some thoughts about where that would come out. First thing I want to say is, as beautiful as I think 48 Wilmington is, clearly mistakes were made back then. Very clearly mistakes were made, and you have corrected them, and I thank you for that. So it's not an example of anything going forward. It's an aberration, but nevertheless, you address that, and I want you to know we really appreciate that. I tell you, the one problem I have with the height that's in the report that we got from the building inspector is that the height on the residential was calculated from the bottom of the second floor. And there's just something about that that, first of all, the code very clearly says that height is measured from the center of the street. So to measure it from the bottom of the second floor is just wrong, in my opinion. It really is. However, if you take a literal interpretation of the height limits in the code for residential and for commercial, and you've just done a comparison of side by side and how that would look odd. Well, I have another one for you, which is the building could be built to code. First of all, I agree that there's no specific height for mixed use in the code. There are, however, some hints of where we should go, and I'll get to that in a minute. But the literal interpretation would have the residential on the bottom and the commercial on the top, because then you'd have your you'd be under 35 and you'd have your 42. But historically and the goals of the CDP, nobody wants that. You know, that's not practical. You've already talked extensively about the other elements of the code that do speak to mixed use, the setbacks and the provisions for FAR. And it's been my experience, and I know that Mike Strange has been on the Planning Commission longer than anyone else and can remember back to the days of the Avenu Inn, but it was very, and of course that was your building, right? Very specifically stated that the code would be applied to the Tier 3 on the ground floor, and it would be applied to the upper levels. And so I think to handle the two components differently, we have a history of that. So where I come out is that because the building contains a Tier 3 use, I think the 42-foot limit is appropriate, and in fact, you're a couple of feet under it. So that's where I get there. But in the future, I think that we should still measure from the street and just use this, and maybe by doing what we've done today, we can set a precedent. There really hasn't been one before. But at any rate, that's where I come out, is because the code has other areas that provide for an interpretation factoring in both uses, that it works here.
Thank you.
That's all I have to say.
I don't think there's a response necessary, Mr. Force, unless you're ready. Yes, sir, Mr. Strange.
Yes, I have a similar comment to Ms. Gay. This represents a very significant use and done in a very appropriate way. And I think it's important to note, as has been pointed out, that our mixed use, the way it's currently explicated within the code, is actually not very good.
Right.
And when you compare that to other towns that are similarly situated in other states that happen to have an ocean on one side and limited access coming into the city, and in fact, in our CDP, which the city has not acted on yet, that was one of the priority areas, was to look into mixed use, and that hasn't happened yet, unfortunately. And I hope it does soon, because it would be to everyone's benefit. With regard to the accommodations you've tried to make with regard to the folks that live behind this facility, I think that's also very important. But from the standpoint of when you buy property that is on the opposite side of a commercial district, in essence, you may suffer moral hazard, and that's just the luck of the draw. A previous application that had come before this board with ClearSpace would have been a disaster for the people that were located behind it. And I think this one is obviously a significant improvement over that from multiple dimensions. And I think that's very important. So that the issue of the nebulousness of our mixed use designation is something for us and the city to address, not for you to address. And I think this particular embodiment and implementation is in the best interest of everybody. I could argue that it's what they call in decision-making, the least worst option, but that makes it sound terrible. But it isn't. The previous option, which of course it never made it out with clear space, would have been a disaster for the town, the city, everything you can think of, regardless of what the design of the building itself was. This, I think, goes in the exact polar opposite direction and manifests itself in a way that is what the city needs and wants from the standpoint of quality buildings within the city limits, and is for us to deal with and the city to deal with the nebulousness in the mixed-use aspect of our code. My observation. Thank you.
Anyone else? Ms. Davis.
I'd like to echo and affirm Mr. Strange's comments. I think architecturally, you have done an excellent job of presenting and designing some three structures, three buildings that really add so much to the streetscape down around that circle. I agree that the prior design provisions for clear space, I agree with everything Mr. Strange said. I have to say I feel personally vindicated in some respect because I was one of the appellants in the clear space case and agreed at that time with the analysis of what clear space would, in my view, and other appellants' view, would do for the city. And I'm so glad that we took that stand because this is exactly the kind of project that I personally would have wanted to have seen come out of that. And one last thing is, Mr. Ellison is better, as an architect, better qualified to comment than I am. But I think architecturally, my understanding is that you could not, and you correct me if I'm wrong, but the architectural features, the gables, first floor commercial with higher ceiling heights, all of what went into designing these three structures really could not have been done in such a way that would have been architecturally pleasing and maybe even practical for operation purposes if you had been confined to a 35-foot height limit that would be applicable if you treated this project as residential or you measured it from the street and only went up 35 feet. So I agree with Mr. Strange. Our code leaves much to be desired. There's no specific height limit for, quote, mixed use. And certainly in this case, and it is zoning, it is commercially zoned, it's in a commercial district. And I agree that, the primary use, at least for purposes of the city, will be public use, will be the shops underneath with a commercial use. And so I think the 42-foot height limit is certainly appropriate and I think defensible from a zoning code point of view.
Thank you.
I just have a couple of questions for the building inspector, loose ends more than anything else, mostly because I've forgotten. There are other approvals besides ours and besides yours that go into this. Are these lots, do they have to be looked at by the Sussex Conservation District because they're 5,000 feet or not?
If they are over 5,000 square feet is the trigger for them.
So they do not have to because they're 5.
Correct. There's no standard application process for that.
Does the state fire marshal have to weigh in or is it only local?
The state fire marshal will have to weigh in on it. And it's important to keep in mind that there is no local fire marshal per se. It always goes through the state.
The state fire marshal, okay. And then water and wastewater, okay. And are there any other external approvals that are necessary?
Del Dot may come into play because of entrances that close to the circle, but we'd have to see where the exact line of cutoff from Del Dot is. I know it's approximately right around that area where they cut off their jurisdiction.
Yeah.
So we'll just have to be sure that we dot our i's and cross our t's with Del Dot.
Okay. And I'm assuming there's nothing related to FEMA or anything because it's not enough.
That's correct.
Okay.
Nothing about plus.
I don't believe, no. 5,000 square foot lots.
Jim has a question.
Okay, yes, sir.
Yeah, I want to address a couple of issues. First of all, I totally agree that the architecture is beautifully done. I think Mr. Shokoff has done a terrific job with all of that, and I think it certainly improves the streetscape in so many different ways. just well done. And I totally agree that we would not have the fanciful roof forms were we to try to, or have to limit, the building height. So I'm all in support of that. Certainly, I appreciate it very much as one of the principal authors many, 17 years ago or whatever it was, one of the principal authors of the design guidelines.
When Vince was in high school.
Yeah, when Vince was somewhere in school, yeah. But here's what I have a serious concern about, and it really has nothing to do with the code. It does have to do with a proposition that is stated several times in various locations in the Comprehensive Development Plan, and that is about impact on neighborhood and residences in the area. I really believe that Mr. McCarthy and his investors know exactly what they're trying to do here. And there's nothing wrong with it, let me state that at the outset. But I believe that their intent in stuffing 5 bedrooms and 5 baths, et cetera, into each one of these units, I believe what their interest is in maintaining those properties and renting them, particularly during the season, to large groups of either friends or family. This is exactly what we have called mini hotels, and we've also heard a great deal about the impact on the neighborhoods as a result of many hotels. That is the number of cars that end up, being involved in those rentals. So my concern has to do with in essence, the number of cars that are going to be generated by these, and I hope I'm wrong on this, but I would say that you might have up to 5 cars for each one of the rental units, plus you would have somebody manning or staffing the store, plus hopefully you would have at least one customer. So you could have up to 21 automobiles at any particular point in time, and you know what's going to happen to those. You've met code by providing 2 spaces for each one of these units. What happens to the rest of them? They go around the Royal Farms and they end up then on Columbia Avenue and Sussex. And I think that is potentially detrimental to the neighborhood. So that is, I don't know whether you have any response to that, but that is clearly my major concern. Thank you.
Yes, sir, thank you.
Can I add a comment related to that? And I won't take very much time. I will borrow a phrase from Mike, and that is moral hazard. You encounter moral hazard buying a house in this city if you expect to be able to park your car on the street. I'm directly across from the currently vacant Walls property. At some point, there are going to be 4 or 5, 6 bedroom homes over there because those are oversized lots. They're only going to be required to put 2 cars in each driveway. Where are all those other guest cars going to be? The city has neglected to address this issue, and I don't think it's appropriate for us to have these debates in a venue where that problem can't be effectively resolved. The applicant has met what the code requires around parking. If the city is unhappy about the code, then the city really needs to step up and do something about it. And everything nice that everybody has said about this, I'll just echo all of it. I live in that neighborhood. I really like the look of that. It's going to go a long way to help to continue and maintain the walkability and the human scale of that part of Rehoboth Avenue.
Thank you, sir. Anyone else? All right, let's open the public hearing, and if possible, we'll do it for all 3 projects at the same time. We'll consolidate them. If, however, someone has a concern about a particular project, please tell us that right from the beginning, and we'll deal with it in some fashion. But is anyone here to provide public comment to these applications? Be right with you in a minute, sir. This gentleman's first. Yes, sir.
Hello.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth to the best of your knowledge and belief?
I do.
And name and address, please, sir.
My name is Drexel Davison, and my business, Bad Hair Day, is at 20 Lake Avenue.
Yes, sir.
And I was pleased when I heard about the opportunity to come today and show my support of this project. I've been in love with it since I first saw the visual. Also, I want to support Dave and Walt. I'm a big fan of their aesthetics. They've got such great taste. I love every project that they do. When I drive down Rehoboth Avenue several times a day, I love to look over at their building, their office. It's so simple, but it's so beautifully done. And I love it for every season, including Christmas mostly. I can't wait to see what you boys do with this at Christmas. I was pleased to be able to meet this architect. I didn't realize he was the architect for my other favorite properties in town, the Avenue Inn and the South Moon Under. I've often looked at those buildings and thought, if only that architect could be in charge of Rehoboth, we'd see a lot less stucco board for sure. Fun fact, when I was a young man, I lived in the cottage in the summers behind 419 Rehoboth Avenue. Still sits there today. It's yellow now. It was white back then. And later in life, after I opened my business, it was housed in the front house for a decade. And at the time when I moved in to the front house, the Cosmic Bakery was next door. And the nice couple that owned it, he would be up all night long making pastries. And she wrote me a beautiful letter welcoming me. And I was so impressed at her love for the crepe myrtle that sat on our property line. I moved in the winter, and she told me when it would bloom, what color it would be, how magnificent it was, and she'd hoped that I would love it as much as she did. And now, over 30 years later, I'm sitting here hearing about the crepe myrtle. And so I'm pleased to be here today. Thank you for addressing the parking issue. We can't let beautiful things not happen because we haven't addressed the bigger picture of parking. I hope this passes today. I hope they get the green light to move forward. I can't wait to see it at the entrance of our town, and I can't wait to see it dressed up at Christmas at the entrance of our town. Thank you.
Thank you, sir. Yes, sir.
Good afternoon. I'll wait till I get there. I'm usually pretty loud anyway. Good afternoon, Commissioners. I am Bob Cartwright, and
Swear
many
you
of
in,
you.
please, sir.
What's that?
Do you swear and affirm that the information, testimony you're to give today will be true and correct to the best of your knowledge and belief?
So help me God.
Thank you. And do you please give us your name and address?
My name is Bob Cartwright, and I am a multiple business owner here in Rehoboth Beach. And I was at our last Planning Commission meeting, and in referring to baseball, as Babe Ruth would say, Babe Ruth hit this one out of the park. And with all of you together, we're looking at that, and I'm thinking this is going to be a crown jewel. Everything that our applicant has done, Dave McCarthy and his people, have always been something that it's their own home on Baltimore Avenue, to Houston White, every single thing they've touched in this community, even the houses that he's developed in different sections of Rehoboth as an architect himself and developed them. I would just like to say he's hit it out of the park. And I do hope you give him favorable recommendation today, because I really think this is going to be the crown jewel of when you walk in, ride into town and see all those beautiful buildings there, because it's got everything. Thank you very much.
Thank you, sir, very much. Yes, sir.
Hi, how are you? Do you
swear and affirm that the testimony you're to give here today will be true and correct to the best of your knowledge and belief?
I do.
And your name and address, please, sir.
Yeah, my name is Bill Honor Frychuck, and we're over on 36 Virginia Avenue.
Right.
Excuse me. I'm just want to say I've watched the progress, because I live out of town, but I get the emails, and I go on and look at some of the things that are going on in the city. I've kind of watched this development. And as somebody that comes in every few weeks and drives around that circle in Upper Rehoboth Avenue, what a wonderful way to enter the city. I just kind of concur with all the nice things that have been said, and I just think it's so appropriate for our town. I agree with the parking issue, like everyone in this room, but this isn't where to answer that problem. I think it's just great, and I look forward to making the turn on that circle and seeing that when we pull into town.
Thank you, sir.
Thank you.
Anyone else? Yes, sir. Do you swear and affirm that the testimony you're about to give will be true to the best of your knowledge and belief?
I do.
Thank you. Rick Perry, 46. Yes.
I guess you know me. Yep. I am so pleased today to hear the, what I will call accolades, not only from the public, but also from a number of the commissioners regarding this project. I've long felt that this is truly an amazing opportunity for us to demonstrate to our community what we will allow to happen in our downtown area. I've grown sick of looking at that empty lot for some time now, and I think that Dave McCarthy and his folks have just created something that we can all be proud of. And so I thank you for your hopefully favorable consideration, and thank you very much.
Thank you, sir. Anyone else? Last call. All right, I'm going to close the public hearing.
I'll take last call. Just to thank you all for your time and your commitment to our city. Thank you.
Thank you,
Thank
sir.
you.
Being of service.
I think we rented cots and blankets and stayed last night. Anyone else? All right, do I have a motion?
I would like to make a motion to approve site plan application. We're going to be doing these separately, right? Since they are three separate plans. Where'd Vince go? Okay. Yeah, three separate. So we'll start with 413, okay? So I make a motion to approve site plan application number 0323-01 for the project located at 413 Rehoboth Avenue, tax map parcel number 334-13.20 to 164, lot 137. With the following conditions, and that is to receive approvals from the state fire marshal, from DelDOT if required, and from the city's water and wastewater department.
How about any other applicable agency?
And in any other applicable approvals necessary in the code.
Anyone else? Any hearing that motion, is there a second?
I second.
Right. Mr. Janis, before we go any farther, are there any other approvals or anything like that that we need to put in this resolution?
None that I can think of. I think we've addressed the other state agencies. Obviously, we have our own interdepartments that need to get the approval, and obviously the building code needs to be approved. But I think from that standpoint, I believe that captures all of the jurisdictions that might have any kind of authority to this project, to these projects, or this one.
And we probably should just add other city codes, because the tree code is not technically in the building codes. So
That's
just
right.
any applicable city codes.
That's right.
Okay.
All right, so we have a motion and a second. Any discussion? A roll call vote, please.
Again, just make sure you please state your reasons for your vote, please.
Okay, calling the vote. Commissioner Stockdale?
I vote to approve the application. I would repeat what others have said. This is a very tasteful design. It's certainly consistent with the CDP, and I would just echo some of the comments and discussions we've had with, we've heard earlier about the need for the city to look again at its ordinances that apply to mixed-use properties, and to come to grips with the parking challenges the town faces.
Commissioner Ellison?
I would love to be able to approve this project. I think it is wonderful, but I am deeply concerned about the impact on the neighborhood, and for that reason, I will abstain.
Commissioner Davis?
I vote, excuse me, to approve the project for the reasons that I previously stated in our discussion. I think it meets the zoning code as I see the zoning code, and apparently the building inspector and Wallace Montgomery do also. And it's certainly aesthetically and architecturally very pleasing and appropriate to the site and to the broader neighborhood. And I think we're fortunate to have a property owner who's willing to put the time and money into developing these three homes or properties, commercial and residential properties, that will now grace the area of the circle.
Commissioner Strange?
I vote in favor, and I believe it's the best possible alternative given the nebulousness of our mixed code regulations. But I think this particular design and implementation is 100% in keeping with the CDP, notwithstanding the parking issue, which is a problem that is prevalent throughout the city, and that approving this doesn't in any way create a significant contribution to the problem that we have in the first place.
Commissioner Dewey, myself, I'm voting in favor of this plan, primarily because it fits in so nicely with the comprehensive development plan. It speaks to maintaining some of the important architectural integrity of Rehoboth Avenue. In fact, it restores some of that integrity to that neighborhood. And those are my primary reasons. Commissioner Gay?
I vote in favor enthusiastically of this project. I think it's absolutely beautiful, stunning architecturally, and is a perfect use for those, well, we're voting on the first one, but for that lot and for the others as well. And I echo what my colleagues have said about both the project aesthetically and about its meeting our current zoning code.
And Commissioner Bryan?
Yes, I vote in favor for a lot of the reasons that have been stated here today. In fact, I'm not sure I object to anything. The parking is a problem. We need a mixed-use zoning code, but we don't legislate. We just create when asked. But yes, I vote for this and wish you the best.
Again, the effective date of the votes here will be the date that formal written notices of decision will be reviewed and signed off. Of course, it'll be consistent with the vote that was just taken. Oh, I'm sorry. Oh, as that, we've got to do the same thing on.
Yeah, we're going to have to do this. Yeah,
Thank you.
3 times.
Yeah, but I don't know if you're going to, are you going to go through anything, any of the findings for the others or not? No? Okay. Then we'll just do 3 separate motions. Yeah. So can somebody else do the next?
We can restate the motion that we did this time. So for 415, restate.
Oh,
Just make another motion for each of the other
you want me to do
two.
'em?
And then, but you can incorporate, if you want to, if that's your view,
the
you can incorporate your votes and reasons from the prior.
I feel like I owe everybody an apology because I think we were going to get out of here on just the one, but but technically, as Mr. Mehta said,
well,
I think we've got to
you want me
do
to
all
do
three.
like lot number and parcels and all that? Okay, here we go. All right, I make a or motion to approve the site plan for again, application number 0323-02, which is lot number 139, tax parcel 334-13.20-165 for 415 Rehoboth Avenue, with the conditions of the approval of the State Fire Marshal, the City Water and Wastewater Department, any required approvals of DelDOT, and any state, city, or federal approvals necessary.
State, city, or federal, okay.
Yeah.
Is there a second?
Second.
Any discussion? Any opposition? All those in favor, a roll call vote.
It has to be roll call.
Do a roll call, but you
That's
can
what I'm
just
asking.
incorporate your prior votes.
Yep. Roll call, please.
Calling the roll, Commissioner Strange?
I vote in favor for all the reasons I had for the previous property. They're identical for this one.
And Commissioner Bryan?
Same, I vote in favor for the same reasons that were articulated for the previous.
Commissioner Gay?
I vote in favor for the same reasons as the previous.
Commissioner Dewey, myself, I reiterate my prior reasons and am very happy to vote in favor of this. Commissioner Stockdale?
I vote in favor for the same reasons I stated previously.
Commissioner Ellison?
And I abstain for the reasons that I previously stated.
And Commissioner Davis?
Yes, I vote to approve and incorporate by reference comments that I made for the previous application.
Okay. Motion carries.
That motion is approved. That application is approved.
Thank you.
Ready for the third one?
Yes, ma'am.
Okay. So I make a motion to approve the site plan application for number 0323-03 for lot number 141, Rehoboth Avenue, tax parcel map 334-13.20-166, the address being 417 Rehoboth Avenue, with the following conditions: that it receive approvals from the State Fire Marshal, from the City Water and Wastewater Department, from DelDOT if required, and any other city, state, or federal approvals necessary.
Is there a second?
Second.
All right. Any discussion? Any opposition? Roll call vote, please.
Calling the roll. Commissioner Ellison?
I abstain for the reasons previously stated.
Commissioner Davis?
I vote to approve the application for the reasons previously stated.
Commissioner Strange?
I vote in favor of this application, excuse me, for the same reasons for the other two applications that I voted yes for.
Commissioner Bryan?
I vote in favor for the same reasons articulated previously for the other two applications today.
Commissioner Gay?
I vote in favor for the reasons I stated previously, but if you'll bear with me for a minute, I have two closing remarks to make. One is, and it's been stated by a number of people, the inferiority of our mixed-use code. It was in the CDP in 2010, and it was in the new CDP in 2020. And it was, in fact, a much more detailed section of the current CDP, and the time is definitely now. And I would implore the mayor and commissioners to get on with authorizing the Planning Commission to create such a code. That's what we generally have done in the past. We have been the ones that would study it. We obviously have wonderful planning consultants and a building licensing department to work with us on that, but we can't do it until the mayor and commissioners authorize us, and I certainly implore them to do that. I think it will be make our job a lot easier, and I think it will be much more fair on the applicants. But having said that, I would also like to note something that I'm particularly proud of right now, and that is that of all the site plans that have been done, and there haven't been that many, but in all the ones that have been done since the ordinance was written in 2009, this approval has been the fastest one ever. There was one concept meeting, one preliminary meeting, one public hearing. I wish they could all meet that, and I thank you for working with us to make that happen. And I'm very pleased that we could expedite the proceedings. In saying that, I will also say that I am perplexed and disappointed that at the last meeting, a number of public comments suggested we would disprove it, suggested we didn't like it. We have said from the very beginning how much we like this project, how beautiful it is for the space. And what we were doing in the interim was, first of all, going over the code-required elements, and secondly, dealing with, as we've all said, the sort of inferiorities of the mixed-use code. But we've done it in a particularly efficient way, and I think we should all be pleased, and you should be pleased with bringing us this project.
I'm certainly pleased, but I probably had the easiest job of all this. I mean, obviously, as I think you
But let me interrupt you so we can pass the motion to approve it. Otherwise, you've only got two.
She looked right at me. It was
well,
you
don't vote.
Got one or two
We
more
can't
votes.
let you vote. I know you'd like to.
I vote aye.
Commissioner Dewey, speaking for myself, I'm voting in favor of this for all of my prior reasons. And Commissioner Stockdale?
I vote to approve for the reasons previously stated.
It's unanimous with one abstention. It's, yes, the motion passes. The application is approved. All three applications are approved. And we're going to make our 4:30 deadline.
And I would just like to
amazing.
say, to respond to Ms. Gay, you know, we did have a real vibrant discourse at the preliminary meeting. But I
one
think
way to
that's
put
good
it.
for the overall project. But, you know, I know you looked at me, and I think you understand that I had the easy job in this. When you have good folks who are designing and have a good sort of model in mind for what they want to do, and certainly good architects like Mr. Shulkoff and Mr. Gross, and a good collaborative effort, frankly, with the city as well, you know, we can see good projects. So, I mean, really not much credit goes to me. It goes to all these design folks and the people who own the project.
Well,
So,
I
but
think
thank you very much.
I think you're right.
Thank you.
Thank you.
You're welcome. Have a great weekend.
I would like to extend some kudos as well to the design team. Actually, one of the first that actually listens. So, commend you.
Always hope.
Thank you, Matt.
And thank you all
I appreciate all your work
your
and all
work on
Matt, that you guys put into it.
Members of the commission?
Yeah.
Yes. Yes.
Oh, the minutes. We never did that.
Minutes.
Yep, we've
Is
got to
that what you're
approve
asking?
minutes.
Okay, members of the commission, your attention, please, for one brief moment. I'd like a vote to approve the minutes of the regular meeting held on July 14, 2023. Is there a motion?
Motion to approve the minutes as stated.
A second?
Seconded.
All those in favor of, anybody opposed? Okay.
Aye.
Aye.
Aye. Thank you.
Thanks, Dan, for the reminder. I forgot about that myself. So are we adjourned?
We're adjourned. We're adjourned.